Good morning. Welcome to the Vincent and Elkins, what we hope is this is our second annual Navigating the Annual Meeting and Reporting Season. We appreciate those of you who are joining us online, and it's great to see a bunch of you here in the room today in person. Maybe that will be a growing trend that will I just find more enjoyable. It's also nice to talk to people instead of talking to a camera. I don't know how the TV news people do that, but certainly I don't. I'd like to, first of all, start by thanking our team who has put this together. In particular, Audrey Kuhas and Kelsey Broussard, who have provided a tremendous amount of coordination for the logistics here, and a special shout out to Chloe Schmergel, who works in our governance group and who has carried the laboring oar on everything on this conference. So thank you, Chloe. I was trained in the checklist manner of practicing law. The way a colleague of mine described it, who married a partner of ours, was when they went to buy a new house and to fix it up and get ready to move in, suddenly there was this checklist, and they knew they were moved in and done when the checklist was completed. And I'm a big believer in checklists as a way to help us avoid ignorance, which most of us don't have a big issue with, but also just to use a harsher word, the ineptitude or the mistake that can happen so often when a lot is going on and you're relying purely on your memory and your own experience to take care of whatever the crisis is. And so in my practice, I find that having a good checklist, usually 3 or 4 checklists, kind of an overall timeline, key steps, an issues list, and then of course the detailed document list. That's a way of providing structure. It empowers the younger people on the team because it helps them understand better what's going on. It facilitates communication among the team. And so we've bought into what a book written about, 13, 14 years ago called the Checklist Manifesto. And you'll see a little influence of that in what we're doing today. We've got 3 hours to cover a lot of topics. That limits the depth we can reach on these. Several of these topics will be subjects or have been subjects of separate presentations from the firm. When you fill out your evaluations, or if you just want to drop a note with the people at the desk or on the chat room, if there are pieces of this you'd really like, either personally or in a broadcast setting like this, a more in-depth discussion, we want to facilitate that and choose the topics that you will be most interested in. So please feel free to let us know what those are. Today, in a sense, we're doing some checklist stuff. We're going to try to give you right here at the start a high-level checklist of what the big issues are on what's new this year, what you should have done last year, but you might want to review and spiff up, and what's coming in the future. Perhaps you're praying fervently that it's not coming. Maybe you've found religion in some of these things. I'd like to thank the team that's presenting. I have with me Scott Rubinski, who's a partner in our capital markets and M&A group here in the Houston office. I'm Robert Kimball. I practice in the capital markets M&A group in the Dallas office. Rebecca Fike is a former SEC enforcement member who has joined the firm, started at the firm, went there, has come back to the firm. She will be presenting after us on SEC enforcement. That is your participatory ethics time, so I know you won't miss that one. We will have a break following her, and Matt Dobbins in our environmental group and Sarah Morgans in our Capital Markets M&A Group will speak to us about sustainability and climate disclosure. We're going to have a couple of, Catherine Frank, also from the Dallas Capital Markets M&A Group, will talk to us about some of the shareholder proposal issues, and then we'll switch to a little bit remotely from Lawrence Elbaum and Patrick Gadsden, who lead our highly rated, our top rated nationally activism practice. Now, when I say that, don't think any of these other areas we're not also top rated, because we're tops. We'll have a break after them, and then we'll hear from a counsel, rumor is soon to be partner, member of our Employee Benefits Executive Compensation Group about some of the recent compensation disclosure developments. And then Jillian Hobson, a partner here in our Capital Markets M&A Group, will remind you of some governance items that you may want to think about doing. And if there's time left, I'll wrap up with a discussion of how to improve your MD&A. And we'll have lunch for those who are here in person at noon. So that's what our morning looks like. You'll get, you have materials. We're not going to hit everything in these materials. These are prepared to be both presentation, but also supplemental resource information, links to sources, things like that for you. Some of these checklists are things that are mandatory, what the SEC requires. Others are things for you to consider and discuss. This year, the commission proposed 29 new rules through November 2nd. That is twice as many as in all of 2021 and more than any of the past 5 years. Chairman Gensler said he's front-loading his agenda. The pace may slow down in coming years, but that's a pretty high volume of new material to digest. You may have noticed a lot of these came with very short comment times, 30 to 45 days, often running from the date of the meeting as opposed to the date of publication in the Federal Register. That suggests an unwillingness, in my opinion, to consider comments, and yet, surprisingly, a few of these have not moved on original schedule, which suggests maybe they really are considering comments on some of these. So we've got a lot to deal with, and we're having to select among all of those to try to pick those that are most relevant to you. The required changes in 2023, we've summarized here. Many of these are going to be discussed in better detail later on, but certainly the universal proxy card is one that you should all be paying attention to. The pay versus performance that has come out in final rules, clawbacks have just come out in final rules, but not yet adopted at the exchange level. So that's sort of in an interim stage, and that's why it's not on this list. We'll talk a bit about some of the key MD&A recent events in the very last panel that the SEC certainly has called attention to and that we see. So there's a few different things in here just to be aware of. Scott, what would you like to say about universal proxy for a moment? We do have, go ahead.
Yeah, sure. Like Robert mentioned, we're going to touch on some of these topics. They'll mainly be dealt with in more detail later on. But universal proxy, many of you might have heard of this. So it's a new rule that is currently effective dealing with director nominees or directors who are up for election. And the new rule will allow all duly nominated directors to show up on the same proxy card, whether they were nominated by management or by stockholders. So the importance of this, we think, is that now stockholders are going to have the opportunity to sort of mix and match between management slate and an activist slate. And so we think it's more likely that activist nominees are, because they're on the same proxy card, may end up getting elected as well. So this is one that we're going to touch on a little bit later on some other panels regarding shareholder activism and things like that. But this is definitely one to be mindful of. Pay versus performance is another new one this year. So most of you with fiscal year ends will include pay versus performance disclosure in your proxy statements this year. And the new rule, it requires you to include a new table comparing your pay versus performance on certain required metrics. And then it also has you list out what the key, most important performance measures are for your company. And there's some discretion that you have about some supplemental measures that you can show as well. But we'll talk about this, Dario, we'll talk about this a little bit later, but this is another new one for your proxy statement coming up this year.
I just read yesterday an article that studied pay versus performance in the medical profession, where they were providing performance pay to surgeons and medical staff to reduce infections and other problems that have happened in surgery. And they found that pay for performance had about a 2 to 4% improvement. So if that translates over into the business world, we will have put a lot of effort into nothing.
Alrighty, next up, for those of you who are at companies that do oil and gas or mining or anything like that, there's new rules that will begin to apply. Really, your disclosure will start in 2024, but there's work to start doing in 2023 regarding resource extraction issuers. This is going to require ultimately disclosure of payments made to foreign governments and also the U.S. federal government in connection with the commercial development of oil, gas, and minerals. So like I said, no disclosure will be required until 2024, but we think people are going to need to start, obviously gathering all that information over the course of 23 so that they're ready to disclose in 24. Obviously, a lot of our clients are in this field are going to be having to deal with this. We plan to have a separate CLE just on the resource extraction issuer rules. So stay tuned for that as well.
And that really means you've got to have your financial systems and other systems in place to track that. So
right.
That should have already been going on. If it hasn't, that's a kind of a red flag issue for those of you in that space. So the MD&A standard continues to be, as was articulated at least as long ago as 1989, that if there is a known fact or trend that may have a material effect in the future, you need to disclose it unless you can reasonably conclude that the material effect is not likely to occur. So the SEC has, over the last couple of years, put out a lot of letters to CFOs and comments to people's MD&A and general statements flagging a lot of areas that at a minimum ought to be on your checklist in your disclosure committees as you go through and talk about your MD&A to just see whether these issues are having or are likely to have a material effect on the company, and to discuss those and to try to quantify those. Again, we'll talk a little more about this at the very end of the morning, but use this as a little bit of just a questionnaire as you're talking with business units and talking in your disclosure committee about what ought to be disclosed in the MD&A as you seek to refresh it each time. One of the recent areas where there's been a fair amount, I say a fair amount, but it's kind of nascent SEC comment, but enough that the SEC has been calling it out publicly, is a longstanding provision in Regulation SK Item 407H, which is the disclosure about risk oversight provided by the board. And they've sent a number of comment letters. We've tried to summarize on this slide, and I think this is the only time in today's program we're talking about this meaningfully. But they've provided some comment letters, that you can go read, and the response to most of those is, okay, we'll do that in our next proxy, but without saying exactly how they're going to do that. But what they really want to know truly is how risk oversight is allocated among the directors and among the committees of the board, including how it affects your choice of lead director, how you reassess that, how you use management and outside advisors to deal with that. And if you've got a chief risk officer or chief compliance officer, where are they in the reporting chain? Are they 5 levels down from the CEO? Do they report to the CEO or somebody else? What goes on, and who has specific risk responsibilities? Do you have a committee charged specifically with that maybe coordinates with other committees? Or is there no central coordination? But it's one of the examples of the SEC using disclosure and disclosure comments to drive what it views as the right process. So take a look at that summary, think about that, and think about how you would enhance your disclosure and even enhance your board and officer structure to address this area.
A couple more things that are new in 23. Minor one is the change in the filing fee disclosures and methods. So for registration statements and other fee-bearing filings, usually you had a calculation of a fee table on the cover. Now there's a separate exhibit that's going to list out the fee calculation and some additional ways that you can pay. So not a huge one, but one that you'll definitely deal with if you're filing registration statements and things like that. And then at the bottom, we mentioned there's some additional requirements to file some things that were previously only required to be filed in paper form, now going to be required to be filed on EDGAR, including Form 144, and also those glossy annual reports that many of you guys use. Couple additional ones that we'll touch on only very briefly. In 2020, the SEC adopted some rules regarding or addressing proxy advisory firms and when they put out proxy advice. And there were some requirements in there that they would have to provide to the companies at the same time or before they provide to their own clients the advice that they were giving. And it also required that the company, if the company makes a written response to the proxy advice, that the advisory firm would have to provide that to their clients as well. In 2022, those got rolled back, and so those are no longer effective. So that's a change there. And then very briefly for the Holding Foreign Companies Accountable Act, now companies are going to, this is really designed to require additional disclosure and documentation for companies whose audit firm is based in a jurisdiction that sort of the PCAOB cannot investigate. And so you're going to be required to say kind of who your auditor is, where they're located, and if they are in predominantly China, if they're in an area where the PCAOB can't investigate, there's additional disclosure and documentation required. And I will only, sticking with the checklist theme, we're not going to go through these in detail, but this is just a brief checklist and highlight of some of the things that we touched on at this presentation last year that were changes in 2022. So some changes to MD&A, the selected financial tables, NASDAQ board diversity disclosures for your proxy statement, change in the NYSE votes cast standard, and some related party rules that you guys may have considered or tweaked some policies that you have. So there's additional detail in the materials on those subjects, but we won't go through them today because hopefully you guys all already have them. And then as Robert mentioned, now that you guys have all, and now everyone has been through 1 year of, addressing these 2022 requirements, it's a good opportunity for benchmarking. You'll be able to go look at your peers and see how they address changes in MD&A and things like that, and see if there's any opportunities for you to revise or to refine your disclosures in those areas. So good to take a look at those.
And this is just our speculation about where some of the key public company disclosures are. The SEC's already behind its last spring announcements on when some of these are going to be adopted. Again, that gives me hope that they are considering the overall effect, maybe waiting to see what the election looked like. But there's still a fair amount that we think they're going to just go ahead and roll out. We think that's just the mindset of the commission right now, regardless of who won Congress or the Senate. So I think you'll just see a lot more rolling through here, including, as we mentioned, the clawback rule that's now been adopted in a worse form than it was proposed, and she'll be coming in. So with that, we're going to, I think, just remind you that 10b5-1 plans are still under the rules as they've been a long time. We get a lot of questions about that. If you have concerns, just call us on that issue. And let's go to our ethics portion with Rebecca. Glad to have you up here, Rebecca. I'm going to just stay here to try to look pretty. Well, okay, I'll just stay here anyway.
Everyone, I have, if not the most important section, I feel like the one everyone needs the most in their CLE hours. So hopefully everyone's tuned in online and clicking those attendance boxes. I'm going to be talking about enforcement trends. Like Robert mentioned in the introduction, I was at the SEC's Division of Enforcement for 10 years. I left in February of this year and rejoined the firm now in the Dallas office. So it's a very active time to be on the defense side of SEC enforcement issues, and hoping we can pass along a little bit of the wisdom and information I learned both from within the commission, but also now, how it looks from the outside. So today I know we're focused on the shareholder annual reporting and MD&A. So we wanted to focus there first and talk about, what could draw an SEC enforcement action, or even not an action, but just SEC questions, maybe an informal inquiry letter, a subpoena. There's a lot the SEC can do to ask questions, to try to get answers, and that can be expensive and distracting long before it actually becomes in action. So one definite theme we've seen for many years, but that continues, is we generally called an inadequate disclosure of facts, trends, and uncertainties known by management. So seeing the word uncertainties, I know, is a little odd because you're basically disclosing that you don't know something. But what I would kind of add to that is, if you don't know something, and if your management or your executives or your board are considering the fact you don't know a known thing, that's something that perhaps investors need to know, that might give that full picture of either the market, your potential results, how it might affect your business outlook. Maybe it's trends that are completely outside of your company, but you're looking at those trends in maybe another industry or a supplier or an end user. And those trends is something you are talking about, with your management, with your board, as it relates to your own business. That's something to then think about whether or not that needs to be in your company's MD&A. And there have been many cases where the SEC has found that. Another thing to focus on, kind of just overall in your disclosures, is that, and I think increasingly, enforcement staff is bringing cases under, Rule 13A1, 13A11, 13A13, which are about having, your full and accurate filings. And they're bringing those oftentimes without an accompanying fraud charge. So they're not saying, we think you've committed fraud, or we think your, scienter, your knowledge, your culpability is so high that you were doing this, purposefully to mislead the market. But we are saying this was not accurate and it should have been. And it's a lower bar, and it's something to think about as you're looking at your financials, that it doesn't take, a full-on showing of a corporate scheme. It's, simply not including information in your financials that should be included in order to make what you have included not misleading. And Rule 12b-20, you'll also now see used very frequently in enforcement actions that are based on disclosures. And the kind of hallmark of that is that a company failed to include information necessary to make the required statements not materially misleading. And so kind of thinking in that sort of broader view, I think, can be very helpful. A couple other, cases that have been out in the last few years that relate to MD&A. There have been some on failing to disclose the effect of material cybersecurity breaches. That's an area the SEC is taking a very close look. In Pearson, which is one of the cases on that topic, there was kind of a incomplete sharing of information about a cybersecurity breach. So again, there it's where they didn't share enough to make what they did share not materially misleading. So they shared there was a breach. They did not share that usernames and passwords were part of that breach. They did not disclose it, but they did, as it turns out, draft a media response in case someone found out that it happened. There's a lot that they knew that, they felt could be material that they were not disclosing. And in the First American case, which related to a cybersecurity breach, but is really more of a disclosure controls and procedures case, there the actual executives did not have all of the information in order to make a complete and accurate disclosure. And so there it's a disclosure controls and procedures violation, where, the executives really thought what was going in the filings was accurate, but the proper and fulsome information was not getting all the way up the chains that they could make that decision. And that's a violation also.
So the Pearson case, the issue there was that, in fact, it was having a material effect on their business because of loss of confidence and other issues. And so the staff was able to bring that under MD&A through enforcement because they just ignored the financial effects of the breach, right? This was not creating a duty to disclose a cybersecurity breach by itself the way the proposed rules would do. There was a material effect, and they were just silent about that issue. And that's bad. Okay. And then
saying enforcement's bad.
Yeah. And then the disclosure controls issues. There have been cases, private litigation, and SEC enforcement going back decades, well before my career. That's how old some of these are. And the consistent theme is somebody is speaking to the public who doesn't have all the relevant information. And so they say something that's wrong. You go all the way back to In re Carnation, where the company spokesperson says there are no material developments that are causing this market volatility, when in fact, the whole senior management team, other than the spokesperson, was in the middle of a major M&A transaction. And the person communicating was left out. So your disclosure controls and procedures are more than checklists of items to consider. They are teams to communicate with and processes to bring people together to share their knowledge. Those both aspects in disclosure controls and procedures ought to be there. That was the breakdown in the First American case.
Mm-hmm. And then just kind of a note on the enforcement task forces. So most of you have heard plenty about the ESG task force that was launched in 2021. And there, kind of the main thing we've seen so far, it's not that the ESG task force is kind of breaking new ground in enforcement theories. It's largely, well, they're all so far disclosure cases. It's not disclosing either, kind of the full information behind something or disclosing something that actually isn't happening, or at least not happening yet. And, making claims, but it's on these environmental, social, and governance topics, which I would just say anything that touches on an ESG topic right now and any kind of public statement you're making should be checked, 3 extra times. It's not that they're using new theories to pursue those, it's that they're focused on them more than I think they were in the past. In the past, you might have all of these checks and backup binders and everything else for any of your financial reports or certain MD&A disclosures, but maybe something you said about, the company's commitment to, social issues was something you viewed more narrative. I think for a long time, enforcement viewed that as a little more narrative marketing. Now I would make sure you have something that shows the company is committed to whatever issue you've just said they're committed to, that is something that is seen as needing that same level of backup as anything else that you're putting in a public filing. And it's something that is absolutely going to be read, by the commission right now.
So Rebecca, in many of our clients, these, as you just said, these were viewed as narrative. They were viewed as PR type things. And so the responsibility for those disclosures has been sitting over in a group often outside of the influence of legal. What would you tell our many in-house legal people here is the message that they need to send and convince I guess. How would you go about convincing people that it's time for legal to be in the middle of that?
Well, Robert, I have a bullet point on that in the next slide. But I will say, so when I was at the SEC, one of my bigger matters was the Nikola case. And that case, the charges are based on not statements made in public filings, but statements made in Twitter, podcasts, media interviews, areas where the company is speaking through often the PR and marketing channels, and a podcast transcript, is usually going through the PR and marketing channels. And what they are usually doing in those roles is making sure, are these statements consistent with past public statements we've made on these topics? Does it fit with our company's brand? Is this the tone we want to set? They're not usually creating a backup binder. They are not making sure and actually calling the engineers and making sure, hey, this statement, which you said 3 other times and is consistent with other statements, is it true? Is it accurate? Is it factual? And they're not getting the backup on that. And I think particularly right now, both because there are more investors who are getting their information from podcasts, Twitter, media interviews, and other sources than they are getting from reading a company's 10K. It's my job to read them, and I would still probably rather read a company's Twitter feed.
Only the people whose job it is to read them, read them.
Read them.
That's
Exactly.
the truth.
And so you have, retail investors and others who are following what the company's saying in these other forums. And then you have sometimes in a, maybe more traditional setup, you have this legal team, vigorously scrubbing a 10K that only the SEC is reading. And then you have maybe a CEO or other top level executives speaking to the market through these other forums that are not going through that legal review. And I would strenuously recommend that reporting pattern or review pattern or, however that flows up through an organization, especially when they're talking on ESG issues, but honestly, any, be something that is considered a public statement with that same level of import that you put on the 10K that is probably your least read document as compared to, an interview or other format, that absolutely can support an enforcement case. And it's all often, again, because that's what people are reading and seeing, it's where the tips come from that enforcement gets to open a matter. It's from, I heard this guy on this podcast say this, and I don't think that can be right. So you need to think about those statements. It's not just what your investors are reading. It's also what potential, aggrieved investors are reading. It's what, the SEC might be seeing. It's what's being flagged by short sellers or in short reports or in other areas. Those statements are the ones that are, rife for potential to get it wrong.
When the SEC comes in to do an enforcement or think about it, do they look at all those other things? Is that typical, or do they only do it when it's flagged?
No, that's absolutely one of the first places that they are going to look.
Okay, so why is it one of the first places they'll look?
Because it's the most interesting and productive.
Meaning interesting and productive for enforcement action?
Or misstatements, yes.
Okay.
So as an enforcement attorney, I would look there first for potential, issues or problems to ask about. And now on the defense side, I would look there first, hopefully before the SEC does, to speak with our clients about, are we sure this is completely accurate? Is this kind of telling the whole picture? Is there anything else we should add? Should this really old post maybe come down? It's looking through those things and making those changes.
Yeah, so there has been enforcement action.
Yes.
There is pending enforcement consideration, and there will be future enforcement action in those areas, and that will only continue to grow. Is that fair?
That is exactly right. I think that is the most fertile ground for misstatement cases right now. Most public companies are pretty good about their disclosures, ESG type narrative statements notwithstanding, but there are a lot, of some really big, sophisticated companies who do a really excellent job in their public disclosures that even, the official, we're not talking about some employee's Twitter feed, they're not speaking for the company, but the, at company Twitter feed.
The CEO?
CEO would be speaking.
An electric car manufacturer?
I would want legal reviewing posts of a CEO's Twitter feed, particularly if the company's name is part of their Twitter handle. I would look at that very carefully. It can be a great way to speak to the market and speak to investors, but you raise potential Reg FD issues, which is kind of a whole other branch of making sure investors know that is a place they can get information, and making sure it's accurate. And whether you've told investors to look there or not, you need to make sure that information is accurate. And it's the easiest place to mess up because oftentimes CEOs become very successful, particularly at startups, because they're really good at telling a story. And that's great. But when you're a public company and, now your disclosures aren't matching your Twitter feed, that is a problem. Or the SEC finds text messages of engineers talking about how the company's Twitter feed is all garbage. You don't want that. And so kind of making sure that all of those statements come together for a whole and accurate picture of the company is something I would make as a priority, going forward to the extent that hasn't already happened. I know the SEC has given you a lot to prioritize, basically everything, but I would add that to the list.
Thank you, Rebecca.
And then one last kind of section, I just wanted to talk about some of the other, trends and things that, I see enforcement focusing on, or, that I was focusing on only a few short months ago. We've already touched on the insider trading and Rule 10b5-1 plans. That's an area where the 10b5-1 plans, give a vehicle for insiders to trade, which is important so they can monetize the positions that they hold. But it's also an area where I think the SEC is really looking to sort of make sure those plans are being entered into appropriately. There was a recent case, the name of which is escaping me, where the plan was entered into when the executive was in possession of material non-public information. So taking that material non-public information, creating a plan that would get to benefit from it and executing the plan does not fix the fact that you had material non-public information. So it's something where, they're really looking around there to make sure those are being used exactly as they should be. And another area is making sure they are always used. So is the plan being followed where it's helpful and then not being followed where, well, it's kind of being triggered, but we think the price will be even better later. So we don't want the plan followed this quarter. So it's sort of an opt-in, opt-out to follow the plan. You can't do that either. And so kind of making sure, those are being followed is definitely important. And then Panawatt was a case late last year where you probably all heard about it by now, but I think it's worth repeating. Panawatt was an employee at Medivation, a biopharmaceutical company that he learned in the course of his employment at Medivation, they were going to be acquired by Pfizer. Panawatt did not buy Medivation, and he did not buy Pfizer. He bought Incyte, which was a company in the same market, which was now one of the few remaining potential takeover targets on the idea that their stock price is going to go up because they're one of the few ones, kind of left that could be acquired by a larger company. The SEC sued him saying that was insider trading, that he used his insider knowledge to buy public company stock. That case is not complete yet. The SEC has not won on the merits yet, but it has survived a motion to dismiss. And the federal court held that it was, in part, that it was Medivation's insider trading policy that supported this, because Medivation defined insider trading as saying that you cannot use inside information you learn in the course of your employment to trade in the securities of another publicly traded company. I've now looked at a lot of our clients' insider trading policies. A lot of them define it in the same way. That doesn't mean you have to change that, but I think it's worth revisiting and rediscussing, with your counsel, with your executives, with your board. Is that what we want it to mean? And if it is, are we prepared to police and govern our insider trading policy in that manner? Or have we unintentionally been broader than we actually want to police, enforce, and potentially watch an SEC action go? And that's another area I think is really worth looking at again.
Rebecca, I just want to underscore a couple of things you said there. First of all, on 10b5-1 plans, under current rules and under proposed rules, there is no scenario where entering into a plan at the time you have material non-public information is good. Okay? Zero. You can have a 3-year cooling off period and you do not have the defense if at the time you entered into the plan, you had material non-public information. Period, end of story. And it's an affirmative defense. You have the burden of proving that defense. So the enforcement action around this has been primarily that. The second area that they've been looking at, but I would say guidance is unclear, but I'm a little more cautious about this area than I used to be. And that's insiders who are selling at a time when the company is purchasing in the market. And set aside the 10b-18 and other kinds of issues being on the opposite side, because you can work through a lot of those. It's clear that we've had commissioners at the SEC that are bothered by an announcement of the initiation of a stock repurchase program and insiders trading in the next week to 2 weeks. They just, even though the numbers are not high on that, even though the dollar amounts really are not very high, even though that's expected because they do those in connection with an earnings release in order to push all the material information into the market so that people can trade, the company and insiders. But there are just some people that don't like the optics of it. And so you just have to think through how you're going to advise your clients about that issue. And then this shadow trading issue, I will say it's a bit of a curveball, but it's a natural outcome of the misappropriation theory. And it fits right into the initial criticism of that theory. Remember that insider trading was originally a fiduciary-based notion. You had to have a duty, like a fiduciary duty or an express duty of confidentiality that you breach in connection with the trading. Then it shifted in the Carpenter case to being a breach of employer policy. And now the misappropriation theory is the most commonly used theory for enforcement. And all it shows is that you breached a duty to somebody. So this, I think, is an unintended consequence of our policies. Our policies, as a general rule throughout the country, say, don't trade on information that you learn in the course of your employment. Mm-hmm. And I think what most of us meant was, don't trade on that information if it's about the company or about a counterparty with whom the company is doing business. But that's not the way the model.
Right. Well, it's not what a lot of policies say. I
mean, it's not what they say. It's not what any model policy said, by the way.
Right, because the motion to dismiss, that's what they said, is that Panawat did not owe a duty to Insight. And the court said, well, true, but he owed a duty to Medivation, and he violated Medivation's insider trading policy. And when you kind of think of it that way, it doesn't seem as far of a reach. They're saying he had a duty to Medivation and he violated Medivation's policy. And so, that's where I think looking at those policies, and again, it hasn't survived, a motion for summary judgment. It hasn't gotten to the end on the merits, but it merits a look at, the insider trading policies and a discussion of, is this doing what we want it to do? And does it have the effects that we want it to have? Said maybe it does, but you're better off knowing what those effects are.
And your other point, I think, is if you've got a policy that can be read to cover shadow trading, the odds are you're not policing that, right, which can give rise to control person liability if the SEC wants to be mean. We all know, and I've been assured by many SEC enforcement people, that they exercise good and fair judgment and would never do anything unreasonable. And if you believe that, don't worry about this.
Yeah. I think, the definition of reasonable can vary. But yes, and so, I think that's exactly right. And that's something that I think the SEC wants you to be thinking about is, if your policy says this, what are you, company, doing to police it? Like, what are your controls and procedures around this policy? And are they as broad as your policy is? And so that, said merits a look. And then we already touched on the public statements, definitely looking there. But on the disclosure controls and procedures, that's something, in my 10 years in enforcement, on the front end of it, it was not something we always asked about disclosure controls and procedures, but I don't feel like I brought that charge in as many cases. Whereas now, in the last few years, if you have a disclosure matter and you're bringing charges about, misleading or false statements or omissions in a disclosure, you will be asked by the commissioners, who are the clients of the enforcement attorneys, how were their disclosure controls and procedures? How did this happen? Were the procedures inadequate? Were they not followed? Kind of who failed here and where was the failure? And those are, very focused questions that enforcement staff are getting, and they are expected to include, Rule 13A, 15A, B, C, whatever is appropriate, disclosure controls and procedures charges when there are disclosure violations. And one thing we did find, and I hope this is getting better, but companies often had a really nice disclosure policy. It was made when either the company went public, it was reevaluated maybe after a large case or Dodd-Frank came out or something. And part of that rule says, has it been evaluated? How have they evaluated it? Has it been, amended? How has it been changed over the years to reflect the market, to reflect the risks that are out there? And it was the rare company where we saw any evidence of an evolution in disclosure control and procedures. And they all, you would ask, the executive in testimony, well, you signed this certification saying that you evaluated the disclosure controls and found them effective. What did you do to evaluate it? And I never had a single one give me an actual answer. It was just, well, I didn't hear they were bad, which is not an evaluation. So something to think about. And again, making that a value add to your company. Look at your disclosure controls and procedures. Are we capturing, what we need to capture? If the risks are, we have a CEO who's really active on social media and we think that's a positive for our company, that's great. What are your disclosure controls and procedures around that? How are you making sure that is not adding risk to your company and then to the investors of your company? Make it a process that adds value. And then as a side benefit, should your executives ever be asked by my former self, they would have an answer. But it's something to look at that I think often gets overlooked.
So I've heard you say it in the charging, and I've heard you say you ask about it in depositions. When you send your initial inquiry, is there a question in there about disclosure controls and procedures?
There often is. It's, that kind of, document sufficient to identify disclosure controls and procedures surrounding, and whether it's some specific statements, pulled from a public filing, or it's just the filing itself, or it's, more broad about, what kind of is your DCP process, kind of how is that structured? But generally there would be something in the initial subpoena about it. And if there's not, and maybe they didn't know it was a disclosure case yet, once it becomes one, you will definitely have additional questions on it.
And do you also ask about disclosure committee, whether they have a disclosure committee?
Yes, although there's less focus on that because sometimes this disclosure committee doesn't, it depends on who's on it and what they actually do with it, whether or not that's a substantive ad. And so usually asking around the disclosure controls and procedures is where, enforcement starts. And then sometimes the answer is we have this disclosure committee and here's what they do. But it's not that having that committee, kind of is a sufficient answer to that question, because you could also sometimes ask the disclosure committee and, they can talk to you about their process for disclosures and ensuring that they're accurate, and that's great. But when you start asking like, well, have you, thought about any changes to these processes or bringing in additional people, or, you're talking about, environmental issues. Do you have someone on your disclosure committee who can speak to those? Even with a good disclosure committee, the answer is often no.
Yeah, so it's and what's the consequence if they don't have a committee or documented process, or it doesn't look like they've evaluated and made changes and enhancements? How did you think about that in enforcement?
It's rare to have a standalone DCP case, like a Rule 13A, 15A charge. You can, that's allowed. You can get that approved by the commission. Usually there's some other disclosure violation with that. It's, 12B20, 13A1, and Rule 13A, 15A. So you didn't include information you should have. There was a misstatement in your K, and we found inadequacies in your disclosure controls and procedures. I will definitely say, though, and I had multiple cases where this was true, that did not include a fraud charge. So it did not have to rise to the level where you're like, this company was engaging in fraud. What you're saying is this company was not disclosing all the information they needed to disclose. They were not following the rule. We're charging them. But it's not fraud. It wasn't a knowing violation. We're not saying that there was scienter there. But those charges can come together and, are a very kind of effective packet of charges that are being approved often right now. And, the facts don't have to be something that supports like a 10b5 theory.
So maybe a takeaway here is, if you were asked the questions she was describing for your company, what would those answers look like? And if you're happy with those, great. If you're a little uncomfortable with some, what will you do to get to a better answer?
We can do a mock interview anytime. But I think my time is up. We've got our ethics credit. Thank you all for listening.
Thank you so much, Rebecca. We're going to take a 10-minute break, and we're going to start, we're going to take an 8-minute break, and we're going to start right at 10.
Okay, we're going to get started shortly here. My name is Sarah Morgan. I'm a partner in the M&A and Capital Markets Group, and with me here today is Matt Dobbins, a partner in the Environmental Group. And we'll be talking with you for 15 minutes about sustainability and climate change disclosure, but that's a lot to cover in a short amount of time. And there certainly is a lot going on here. Some of what we're doing first here is just stage setting. This is Larry Fink's 2022 letter. We haven't seen the 2023 letter, but clearly between all of the large institutional investors, there was a high degree of focus on what you're doing with respect to climate change and disclosures regarding the same. So looking at ISS and Glass Lewis, the proxy advisory firms and their policies on this. So looking at ISS first, their proxy voting policies are really just focused on who they consider to be the top emitters, the Climate Action 100 Plus focus group. I think there's about 167 companies in there. And for those companies, for director elections, ISS will generally recommend against the responsible director where there's not significant enough disclosure risks, and if they haven't adopted appropriate GHG emission reduction targets. So that was the policy for last year. We're going to talk a little bit about the benchmarks survey for this year, which is indicating where things are going. And then when it comes to, say, on climate proposals, they're going to, just like Glass Lewis, look at this on a case-by-case basis, looking at climate-related disclosures and GHG emissions performance, significant violations and whatnot. So this was their policy last year, and every year they do a benchmark policy survey where they interview both investors and companies with respect to what their policies should be this year on a variety of topics. And with respect to climate, there was an enhanced, a significant majority of both investor and non-investor respondents agreed that there's a material governance failure if you're not providing adequate disclosure with regards to climate oversight, strategy, risk, and targets in accordance with the TCFD. And then going to the bottom of this, both investors and non-investors universally agreed that investors' expectations for climate-related disclosure and performance are going to increase over time. And so you can see some of the other information here on priorities. They're focused on whether or not you have TCFD compliant disclosures, and really whether you've set adequate and realistic medium-term targets, and then whether there's CapEx aligned with the strategy, and what are the technical and financial assumptions underpinning the strategy. So again, the ISS policy, I think, is expected to apply to those significant emitters again, but there's an enhanced focus on disclosure, an enhanced focus on setting these interim targets. And then also impacting disclosures are the net zero pledges from banks. And you say, okay, how does a net zero pledge from a bank actually impact me? Well, they've made all of these commitments on financed emissions. And so what does that mean for them? It means that the people that they are banking need to have some sort of emissions reduction targets and be making progress towards that. And they want you to be advertising that so that when they say, okay, we're banking this person, they can prove that they've been meeting their goals too. So it's increasingly important to them that the people that they are lending to are both making these emissions reduction commitments, moving their business towards that, and also reporting on it. These are just some other energy transition commitments from the bank. And then, of course, on the other side of this, you have the anti-ESG movement, which is some of that's within governments, some of that is with investor bases, and the general thrust of this is that people are doing ESG stuff is just sort of, not based on shareholder return models, and that people are doing this not in the best interest of shareholders. And so last year we saw a bunch of shareholder proposals on both sides. And as we'll talk about in a little bit, it's infinitely easier to get a shareholder proposal into a proxy now. And so we expect to see a large number of both climate proponent proposals as well as anti-ESG proposals too. And you can kind of see that both sides of this. And as you look at the anti-ESG shareholder proposals, most of these are focused on whether any of these actions are actually in the best interest of shareholders. Are they producing financial return? And so I think what we saw a little bit as a result of this last year is people started to prepare their sustainability reports this year. People focused more on talking about, what they were doing holistically, how it made sense in the context of the company's entire strategy, and how it was good for the company's shareholders, and whether it was in the short, medium, or the long term. So more a focus on why this makes sense for our organization. Why should we be doing this? And then a lot of talk about, focus on returns within that. And then you also have hanging out there is the specter of greenwashing. The SEC, for example, put together a ESG task force, I think of over 25 people that are within the enforcement division. And they're very, very focused on looking at what people are saying, whether companies are exaggerating their ESG practices, and whether they actually take into account these ESG factors. And so I think that this is something that people also drilled down on this year as they were looking at their sustainability reports, like trying to remove some of the puffery from that. And I think that as you look at this, there was a few key takeaways from the SEC's alert to avoid greenwashing. One is just be clear about what you're actually doing, and then be consistent throughout your disclosures. And then we'll keep returning to this, based on what Rebecca said before, and what we're doing now is just making sure that you have adequate compliance and disclosure controls and other controls around your ESG strategies and disclosures. So I think those are all key as you go to develop your climate disclosures this year. And actually, let's see, it looks like the poll question already popped up. Does your company publish a sustainability report? So please just respond to that. And then, of course, the key thing that happened, this year with respect to climate disclosures is the SEC's over 500-page proposing release on its proposed rules. That is a separate 2-hour session in and of itself. But I think as we talk about what are people doing with respect to that, I don't know that there is any company that I know that is, voluntarily complying with every aspect of the SEC's proposed rules. I think that people are planning to have additional climate disclosures. I think people are focused on certain aspects, particularly with respect to description of climate risk and strategy, and making sure that what they're saying in their sustainability report is harmonized with all of their other documents. But again, I think for the most part, you're not going to see, disclosures that are compliant with these new proposed rules universally through a 10K or a proxy, but I think you probably will see enhanced disclosure of climate risk to the extent that that energy transition, business or climate risk is sort of core to a company's strategy. You'll see more of that in MD&A, and then within the proxy, I do think that you'll see enhanced disclosures of the overall ESG strategy, overall governance and management of climate risk, and then obviously, to the extent that compensation is predicated on some of those ESG metrics or goals, you'll see enhanced disclosure of that there. And TBD on when the final climate rule comes out and what's in it. We've heard, I think the latest prediction was probably late Q1 2023, but that tends to move around a little bit. Okay, I think this was the polling question that popped up earlier. Let's see, looks like 42% of you guys do publish a sustainability report, and then not applicable to 40% of you. Okay, and then just a few final points here on disclosures. In the TCFD 2021 report that recently came out, more people are voluntarily reporting. And along the lines of what I was saying, as you look at, and this is the percentages over the last 3 years, so you can see that it's grown each year. And TCFD, people pick and choose what they want to report. Like I said, you see a lot more people doing comprehensive disclosures on their risks and opportunities and strategy within the strategy section. And then reporting on their climate-related metrics and targets. You've seen increased disclosure there, and those tend to be the ones that are most reported, and we see that consistently in people's 34 Act reports as well. And then if you haven't gotten one of these in the last couple of years and you do publish a sustainability report, you probably have one in your future. It's the SEC letter that basically says, hey, we read your sustainability report. Why isn't all of that disclosure in your 10K or your proxy? And usually the answer and the response that we give on behalf of clients is, here, if it is material, here's where it is, and you missed it. And if it's not material, we didn't include it in there because it's not material. And the SEC has been pretty receptive to that approach. But I think this, along with everything else that we've talked about, just emphasizes the need to make sure that your disclosures are harmonized across all of your disclosures, your 34 Act reports, your 10K, your proxy, your website, your sustainability report, that it's all singing from the same page. And then I think the upshot of this, as we discussed before, is all of this just creates enhanced need for disclosure controls and procedures. I think sometimes sustainability reporting and ESG reporting and even some of the website aspects have been outside the purview of legal. I think within the last year that changed a lot, and we saw more scrutiny from legal and other sections of ESG reporting and more incorporating of that into your 34 Act reporting. So I think we'll continue to see that as well as additional reporting.
All right, thanks, Sarah. I'm going to go through this pretty quickly. So we're not going to go through a history of TCFD. I'm sure many of you generally know that, but emerged in 2017. It's the most common voluntary climate reporting framework. And in fact, the SEC climate proposal is built off of TCFD. So that's one of the reasons why, we're focused on all these international frameworks, reporting protocols, things like that. The most recent update in October 2021 didn't really change fundamentally what TCFD was asking you to disclose, but it gave you more specifics. So that's why, in part, you're seeing the increase in scope 1 and 2 emission disclosures, because those are now mandatory under the TCFD 2021 guidelines. Important thing to highlight is that TCFD is just a framework. So it often points to other protocols, other different frameworks for specific issues. And the GHG protocol mentioned here is how TCFD suggests that a company should inventory and report its GHG emissions. And the GHG protocol is not completely the same as the US EPA greenhouse gas reporting rule. We've talked with several clients, and I would say most appreciate that, but there's a sizable percentage that don't. And so it's very important when you talk about in your public filings, how closely you align with TCFD, that you really run through and figure out how closely do we follow the GHG protocol when it comes to our emissions. That's really important in the context of a net zero or emission reduction goal. These are growing increasingly common. I won't say that that's the trend, but there is increasing stakeholder expectation that companies are going to be setting climate reduction targets, generally net zero by 2050, to align with the goals of the Paris Agreement. So step one of any net zero goal, of course, is inventory your GHG emissions. That's something where you really want to pay close attention, if you're a legal in-house counsel, to what technical experts your internal environmental folks have engaged. You want some extra degree of a third-party source kind of making sure that you've properly quantified all your emission buckets. Then after you inventory everything, you look for ways to reduce it. Some ways you can do that simply through energy efficiency projects, but you're left over with residual emissions, particularly in the scope 3 bucket, which are your value chain emissions. And those are a lot harder to reduce unless you have carbon capture technology to remove carbon dioxide from the emissions, or you're engaging in offsetting measures. So we're going to focus a little bit on carbon offsets here. This slide lays out all the different requirements for them. The point I really want to make are the independently verified and the additionality requirement. Independently verified means a third-party registry's approved your offset for sale on a voluntary market. They've got their own individual protocols for each particular type of offset project. And if what your company's contemplating isn't fitting under one of the existing protocols, you've got to spend time and money to potentially get them to approve a new one. The additionality component is a really tricky thing, particularly now that we've got the tax credits under the Inflation Reduction Act. Additionality is kind of like a but-for test, that but for the value you'd get from the offset, selling the offset for this project, you couldn't do the project. So think about how difficult that can be to show when you start stacking tax credits and environmental attributes. And that brings us to this last slide where we've got new developments in the GHG protocol, which is actually going to provide some guidance about how you account for GHG emission reductions from activities like CCS. And it could really mess with companies that have been leaning in heavily to a carbon reduction business that involves going to third parties outside their value chain and capturing their CO2 and reducing it, if that company wants to count it against their own net zero goal. The other thing we're worried about on the American Carbon Registry side is they will explicitly release a protocol that says you cannot stack other environmental attributes, tax credits with a carbon offset. And just finally, again, we've got the backdrop of COP27 happening. This is the United Nations program that happens every year. And unclear what the drive is going to be, but greenwashing is certainly a concern, as well as additional climate reduction measures, given some of the recent reports about the trajectory for global temperature rise.
Good morning, everyone. I'm Catherine Frank. I'm a partner in our Dallas office in the capital markets practice, and I'll be joined here today remotely from New York. And this is Lawrence Elbaum and Patrick Gadsden, who are partners in our activism practice. I'll begin with a few minutes on the more regular 14A shareholder proposals and proxy advisory firm matters, and then I'll turn it over to Lawrence and Patrick to discuss corporate control contests. And in keeping with our checklist theme, I've worked since I was a young associate with Robert, and he loves a good checklist. When I got married, I actually put a checklist together, a merger of equals checklist. And my first child had an IPO checklist. So it sinks in deep once you start. All right, just as a matter of general interest, I wanted to show you, let me see if I've got this going. I wanted to show you one of the first universal proxy cards that have come up. They've just started to hit EDGAR. And as we discussed earlier, the new Rule 14A-19 provides for a universal proxy card, which includes directors both from activist proponents and from the company. Both the activist and the company will put out a universal proxy card. And as you can see, they are not identical. This example is one of the two that have come up so far. We've got a white and a blue, and they remain still possibly a bit confusing to voters. The company card shows opposition for all activist proponents, but you can see the activist card, the blue card, has three categories. It has the company nominees, the activist nominees, and then a company nominee unopposed by the activists. So we'll see how these pan out and how the votes go. It may still be, a bit of a fight. Both the company side and the activist side were recommending that their own universal proxy card get voted and mailed back, probably so they can track the votes along the way. So that's just a matter of interest, and I think Lawrence and Patrick will probably speak a little bit more about universal proxy cards. We've also, by the way, seen the first litigation in the Delaware Court of Chancery over universal proxy cards. And the court so far has denied the activist motion for a mandatory preliminary injunction to require the company board to include their proponents because the activists did not comply with the company's bylaws, their advance notice provisions. So advance notice provisions remain important even as we move into universal proxy cards. We'll see where this pans out. Okay, moving to shareholder proposal trends. Many of you get shareholder proposals every year. Some of you may not see them, but because shareholder proposals are up about 8% as of 2022, we do want to go through and hit some of the major trends that are coming through. And unsurprisingly, it is the E and the S of ESG that are driving these trends. It's environmental and social. Governance for the first time in 2022 was actually down a bit. And what we mostly saw in 2022 was a focus on special meeting proposals. It was one of Chevedden's pet projects. And while many issuers may already have a special meeting, right in their charter or bylaws, often the proponent was seeking to lower the ownership threshold so that it was easier for someone to call a meeting. And social, which is a kind of a wide range of proposals, were up about 20% last year, largely anti-discrimination and diversity related. They made up about a third of those proposals that are coming through, largely reporting or audits. Environmental went up the most, 51%, and 75% of those were actually climate change proposals. And they were a variety of asks. Some were reporting, some were setting emissions goals. Oh, and I think we've got a poll that's come up. Does your organization have a separate ESG board committee? Yes, no, or not applicable? So if you would click, and I'm actually curious in the audience if anyone is a yes, no, or NA. I don't know if you do a show of hands. If you have an ESG committee, can I get a yes? Okay, can I get a no? About half and half, and a not applicable is probably the rest of you. Okay, just curious. We'll see where it comes from remotely. Environmental was up about 51%, 75% of those were climate change proposals. And civic engagement, which is largely lobbying, political contribution, and charitable contribution proposals, which, as Sarah and may have discussed, often an anti-ESG proposal will be a lobbying or a charitable contribution proposal, asking for disclosure about, where you're putting your money and whether you're putting your money where your mouth is when it comes to, political support, perhaps for the targets that you're also espousing. Executive comp actually went down last year, and one of the biggest subcategories, another Chevedden pet project in 2022, was submitting severance agreements to a shareholder vote. So he was successful at a few companies. We expect those to show up again going forward, since he had some success in 2022. Proposals to tie ESG metrics to comp have actually declined significantly. Those were not successful historically, and so we're not seeing as many of those in 2022. So let's see, ESG board committee looks like no is carrying the day with 38%. Very interesting. All right. So overall, the pattern for shareholder proposals in 2022 is this. Proposals themselves are up about 8%. More and more of those proposals are hitting the ballot. That means companies have not been able to exclude those proposals at the same rate as they did in the past. The SEC had a lot to do with that, and I'll talk about that in a minute. Interestingly, also, the failure rate for many of those climate change and ES, not necessarily the G, proposals has actually been fairly high. And one of the reasons that has been given for that is that institutional investors are a little wary of overly prescriptive climate shareholder proposals. And so the failure rate has been quite high, I think 88% in 2022. So an interesting pattern, right? More proposals, more of them are ESG proposals, more of them getting in front of stockholders, but the failure rate is increasing. After increasing for quite a while, I should say. So why are all of these ESG proposals hitting the ballot? Why can't they be excluded? And the reason for that is, or one of the main reasons for that, is that the SEC has become increasingly friendly to shareholder proponents, and their guidance and their proposed rules reflect that. They've made it much more difficult for companies to exclude proposals. In 2021, they issued guidance that basically made it a lot more difficult to exclude proposals because they were either not economically relevant to the company or they fell under the company's ordinary business. if those proposals reflected a area of broad societal impact or broad social and ethical concerns. And so, of course, in your mind, that should be, oh, ESG, climate change. These proposals were not excluded. They made it through. In fact, the success rate for no action requests in 2021 fell to 38% from 71% in 2021. And that actually doesn't reflect companies who looked at early failures in the season and decided not to submit a no action request later in the season. So you could see that the SEC has been increasingly less likely to support exclusion of shareholder proposals over the last year. One of the other changes they made in their guidance is that the micromanagement proposal, so overly prescriptive proposals, for example, they've said, oh, if an investor can understand the framework or the target and it's a well-established framework, then that's something that investors can understand and can vote on. And so we've talked about the TCFD framework or a net zero commitment. Again, much more difficult to get a no action request letter through to exclude a proposal asking for that kind of commitment or disclosure. But wait, it gets worse. So in this year, the SEC proposed rules to amend 1488 to give in three additional ways. And these focus on the implementation and duplication exclusions. It used to be, you could say, well, we've more or less implemented this idea, not in quite the same way, but we're already handling it. Or these two proposals are substantially the same. They have different ways, but they get to the same result. So we're going to exclude the one we dislike more. And now the SEC has said, the means or the objectives are as important as the goal. So again, we expect fewer and fewer exclusions of shareholder proposals going forward. So checklists. What happens if one of these come in? And you've got a few options for responding, and some of them have very tight timelines and prescribed timelines. So you can exclude on procedural grounds. The proponent doesn't have enough shares or doesn't give you evidence, or they didn't hit the deadline, or they have too many words, the word count is too high. You want to determine that very quickly and call your counsel quickly to run that analysis if you'd like to exclude a proposal. There's exclusion on substantive grounds, and that unfortunately is becoming more and more difficult with the SEC's change. You could try to exclude without a no action letter. That can be dangerous. It is more likely to result in litigation. And then you can negotiate with the proponent for voluntary withdrawal of a proposal. And that really depends on your proponent. Some may be more receptive to that than others. So that's pretty touchy, less likely to succeed. In terms of recommendations, so the letter comes in or you're prepping for a letter to come in, a couple things I want you to think about. One is that you want to track everything. So emails should be saved if you have a document retention policy. Track your mail. Make sure you can prove that you did things when you said you did and you met the deadlines. Stay informed on what the staff considers significant policy issues. Again, with these changes to the ordinary business section where we talk about matters of broad societal impact, what does the SEC think right now is an issue with broad societal impact? Consider providing email addresses in your proxy statements because it's much easier to track an email correspondence than it is to go with certified mail. Be ready to send more than one deficiency notice and to be really specific in your deficiency notice about what the defect is because the SEC, again, is being much more supportive of the proponent in these situations. And then finally, and this is just a practicality, save, copy, catalog everything and make sure your mailroom knows and whoever opens the mail knows. You're going to need a copy of the envelope. You want to see the postmark. You want it to come in to you in the legal department as quickly as possible. And, that's just a matter of training and flagging and making sure that it occurs, but it's that backup that you need to help support a procedural defect case or letter. I'm giving you, just as a reminder, an update, the Glass Lewis and ISS voting recommendations from 2022. These have not yet been updated, but you can see that they did give some guidance for 2023. Glass Lewis will vote in the S&P 500 against the chair of NomGov if you didn't provide disclosure of individual or aggregate racial or ethnic minority demographic information. ISS in 2023 is voting against the chair of NomGov where boards don't have women, and then possibly the entire board at companies with unequal voting rights, subject to certain exceptions. BlackRock didn't give 2023 guidance in 2022, but these were their 2022 proposals. These usually come out in January. And then finally, just maybe a little glimmer of hope. ISS and Glass Lewis have been recommending shareholders not support overly prescriptive or constraining proposals, and BlackRock and Vanguard have both expressed that they won't support proposals that are overly prescriptive, and they'll start reflecting their overall concern for long-term value. So the pendulum does start to swing, but it's not, the help is not coming from the SEC. I'm actually going to go ahead and turn it over to my colleagues in New York.
Well, thank you. As mentioned earlier, Patrick and I'm Lawrence Elbaum. Patrick and I co-head Vianney's activism practice. Over the past 7 proxy seasons, we've defended now over 250 campaigns. We're going to cover a few topics today. We've got about 25 minutes, so we're going to breeze through the few topics. We'll talk about what is shareholder activism, why we think it's going to be more prevalent this proxy season. Universal proxy will come up. We'll talk about the landscape for activism, a bit about what actually happens before a proxy fight, what actually happens in a proxy fight, and how to prepare. Can we go to the slide that says forms of activism, please? Thank you. Perfect. So Catherine's very generously covered the S and the G here. But when Patrick and I are involved in a corporate control contest, whether it's a fight over board seats or it's unsolicited bid to get control over the company, we're dealing with the bottom right, which is economic activism. And that means that an investor, usually an activist hedge fund, has identified a dislocation between the company's intrinsic value and its market value. The intrinsic value is more than the market value. And the activist says, I want to unlock that value. What that usually means is I want the company sold, but it could also mean I want a dividend or a share buyback. I want accretive M&A, or I want a change in business operations. But the S and the G and the E do come up in these situations because the economic activists have realized that from the previous slides, the BlackRocks, the Vanguards, the Fidelities, the Charles Schwabs, the ISSs and the Glass Lewises all want to hear about governance, social, environmental issues connected with the economic campaigns as well. So there is not a single shareholder activism campaign that does not include all these themes, including the ones that Catherine discussed on the previous slides. But in our world, you're not going to see a John Chevedden run an economic campaign that happens to have governance, social, or environmental themes. First, in our world, an activist hedge fund needs to identify a way to make money. Then you'll start hearing about the other letters in ESG. Next slide, please. These are some celebrity activists. We could add a bunch of other celebrities because there are a lot of up-and-comers that have risen to or rising to this level. But we also call this the mugshot slide. But these are economic activists. Some of them were famous raiders in the 80s. Others really came into fruition over the past 15 or 20 years. If one of these folks is in your stock, you'll want to call your activism defense team right away. Usually they only reveal themselves if they're planning on running a campaign. But turn to the next slide. There are a number, and this is 1/10 of the rest of the universe. There are a number of other activists out there. These are ones that you might not associate with activism. You may never heard of them before. Sometimes these are family offices, first-time activists, private companies, private equity funds that have figured out a way to get around their LP agreements to do activism. In other words, every company is a target, and there are many different antagonists out there. Companies should all have a list like this that's 10 times as long, so that you know who you're talking to when you're talking to them, and not after you've had 10 phone calls, a plant tour, and you've opened up the kimono. Next slide. Patrick's going to talk a bit about the activism toolkit.
Sure. Thanks, Lawrence. And much of this was already covered by Lawrence in terms of the economic bases on which activists choose to run their campaigns. But what we've done here is bucket the 4 main types of economic themes that activists use when they are actually running their situations. So the first bucket is the main bucket, and historically has been the most predominant bucket in terms of theses, and that's M&A. But by M&A, in activism world, what we're really usually talking about are sell the company theses. Now, most activists won't actually come out and say that. They'll say they want a strategic alternatives review committee formed. But in reality, if you look at the returns of the majority of your bread and butter activists over the last 15 years, it very tightly correlated with the returns you'd see in an M&A arbitrage fund. So really, many of these folks are just M&A arb guys in governance clothing, and the majority of their work in terms of their returns is done through focusing on sell the company theses. The second bucket is really a shareholder return of capital bucket. It's over the last 10 years or so, it's predominantly been requests for shareholder repurchases, or the initiation of a shareholder repurchase program, or the broadening and deepening of an already announced program. But usually you don't see activists ask for increases in dividends that frequently, unless you're dealing with an activist who's dealing in an industry in which dividends are disproportionately reflected in the total shareholder returns of that particular industry. The next bucket is operational. This actually is fairly rare, and by operational, we're talking about everything that's below the gross profit line. Empirically, gross profit margins are very sticky historically, and activists are very aware of that. They're not trying to help you make the widget better. They're focusing predominantly on SG&A cuts, everything below the gross profit line. And very few activists actually have a history in operations that lends itself to being able to help management with any sort of operational issues. The majority of activists are sort of spreadsheet quant jocks. So operational activism isn't nearly as frequent as balance sheet and M&A activism. And the last is corporate governance, which is traditionally in proxy fight world, changing of board seats, or the requests of changing of board seats. This really is a mechanism to affect the other buckets, right? If the company doesn't do the actual economic or operational things that the activist would like to see done, the activist is then willing to ask for governance changes that could then affect vis-a-vis board changes, the actual economic theses that the activist is pushing. We can go ahead and go to the next slide. All right. Here we have a visual depiction of an increase, as you can see, of shareholder activism over the last few years, actually almost 20 years. So what you'll notice is an upward sloping upward and to the right. What's most important about this slide is not the increase in reported activism. It's the increase in what you can't see here, which are activism situations that never actually go public because they're handled discreetly behind the scenes. And that is actually the majority of activism. So for every contest here or situation here that's listed, there's probably 1 to 1.75 activism situations that are not actually reported because they get handled behind the scenes with informal agreements that never actually get papered or filed for shareholders, but they're more sort of shaking of the hands, nod, nod, wink, wink. We'll give you another year to see if you can figure this out. Please do what we ask you to do. And that's the lion's share of activism. It's the lion's share of work that Lawrence and I actually do day to day. But even notwithstanding that, what you can see here are situations that were not able to be handled privately, went public, and as you can see, there still are increasing amounts of those. So that's what's sort of most important.
Just to add, the blue bar shows campaigns that went public. The red bar shows campaigns that became proxy contests. That means that the campaign didn't get resolved and formal director nominations or business proposals were made under a company's bylaws for an annual meeting. So you could see, and if you actually go back almost 20 years here, it's pretty much a stable number of actual proxy contests. But the fascinating thing, I just picked this up looking at this now, Patrick, in the past 10 years, we're on track to double the number of publicly reported campaigns, which think about that, that's amazing. The number of unreported campaigns that keeps us up at night and mostly busy has probably doubled as well.
Yeah, it's a really good point, Lawrence. And a lot of the increases in campaigns are due to increases in the number of activists, going back to your other slide, and the amount of capital that's been raised in the space. So success in activism breeds more activists. And
attracting flies,
and also allows activists that are sort of more traditionally, known and recognized folks to raise more money and run more situations. So great point. Here we have a visual depiction of ISS recommendations, either for or against activists over the last 10 years or so. What's most important here is that despite sort of, an increase in what we'll call more activist-friendly recommendations by ISS, it really is a volatile type of data point to try and evaluate. It's not anecdotal. We are looking at real campaigns here, but much of this is based upon the types of activism situations that ISS sees every year, and it can be very idiosyncratic. Each of the recommendations is very bespoke, although the recommendations are made through a traditional framework policy that is released. So it's important to realize that although there may be some ebbs and flows here, the important aspect to take away from this is the volatility, and to realize that, if your company walks itself or is walked by an activist into a situation, there's no real reflecting on what ISS has done over the last few years. You have to look at your facts, and look at your facts as reflected through the lens of the ISS recommendations framework, and then try your best to estimate whether or not you are going to be in a situation that's more favorable for the activist or less favorable.
Yeah, and the sample size is small. The number of campaigns that become proxy fights is small. The number of proxy fights that actually go to an ISS recommendation, it's about a quarter. So you may have sometimes a statistically significant number in the 30s. What is it, 35 you need? But the numbers, they're not so large that you can actually make predictions, and you could see the bar charts move up and down.
The same for the next slide for Glass Lewis as well. Pretty much the same data points and the same takeaways. So we can go to the next slide. So here we have pie charts that reflect activism situations that have been withdrawn, that have settled, or that have gone to a vote. As you can see, the most startling or interesting aspect of these graphs are the number of activism situations that have been withdrawn and how that continues to grow. It's a really strange facet. Part of it may be COVID. Part of it may be, as we were mentioning earlier, many situations being handled privately that allow an activist to withdraw its nominations and wait a year to see whether or not the company follows through on many of its implied promises to the activist. But we'll probably see going forward, now that we're in the era of universal proxy, are more settled campaigns. The universal proxy has created a sort of dynamic in which it is more likely the activists will probably get at least one person in the boardroom if it runs a multi-person slate. So what you're likely to see going forward is an increase in that blue pie piece for settled campaigns as it becomes easier to get a minority change in the boardroom vis-a-vis the universal proxy card.
I'll also add that when activists are winning and these go to a vote, we'll get a phone call with an offer of settlement, which really doesn't make much sense. By the way, we rarely lose. So it's a rare phone call that we get, but we do get them when the activist is winning. But the activists will want to settle. Why? Shouldn't they just be thumping their chest, doing a victory lap and crowing from the mountaintops? No, because usually the activists are going for a minority of the board. They realize that after throwing mud at the board for many months, sometimes years, it's going to be hard for them to get board committees. It's going to be hard for them to kumbaya in the boardroom with directors, and they want to start mending fences. And most importantly, the activists, through a settled matter short of a vote at an annual meeting, they can get an expense reimbursement. These things are expensive for activists. They have less money than companies do to fight these things, and they can get that in return. What does a company get in return for a settlement? They get what's called a standstill. A standstill is really a peace treaty. It's a prohibition on public and private activism and a requirement that the activists vote with the company and the board for a sustained period of time. That way the company has runway to execute on its plan, free from further activism. Campaign stages, and I think we have 10 minutes left. We'll go through this. We've spoken about engagement a little bit, but generally what happens in an activism campaign is an activist does a lot of diligence over a relatively long period of time, sometimes a year to 18 months before spending a single dollar. They buy stock directly or through derivatives, and there are a number of disclosure regimes that could be the topic of a completely different seminar. After they've built their stake, they usually reach out to have engagement with the company, and it's during the engagement process that the activism campaign really takes shape. Usually it starts with private engagement. We oftentimes get involved when it's private engagement, and our clients or prospective clients have a list and know who the activists are that may be seeking to engage with them. They're not surprised. But if the object of the activist's campaign thesis doesn't get achieved through private engagement, then you're going to have public engagement. That can range from a plain vanilla 13D filing with the SEC saying we have an intent to influence the board of management, all the way to a white paper and a website, anything in between. If the matter doesn't get resolved through public engagement, and oftentimes it does, then you have a proxy contest. Companies have a 30-day window, usually about 3 months before the annual meeting every year, where nominations have to come in for an alternative slate of directors. If the nominations come in before the 30-day window opens or after, they're not valid and you can reject them. And usually proxy fights are for a short slate, which is less than a majority of the board, but sometimes they're control fights, often when there are really significant governance and underperformance issues. Litigation, a third of the time in activism campaigns. Sometimes proxy fight turn to takeover bids, but it's usually not the activist that's doing the taking over threat. It's usually an interloper that comes in over the top in an opportunistic fashion. Next slide. This is the equivalent of a checklist in mine and Patrick's world. that we have our children working on. But we make a timeline for all of our clients in terms of how to think about what the world will look like during an activism campaign. I mentioned that a notice of nominations has to come in about 3 months before the annual meeting. So you'll see that on one end here. But what happens after that is a tremendous resource, time and cost drain, if you will, on the company. It's a very busy 3-month period of time. You prepare a specialized proxy statement. A preliminary proxy statement has to clear the SEC. Usually takes a few weeks, although it should take 10 days. It always seems to take 2 to 3 weeks with at least one round of comments. There's a significant solicitation effort by both sides in a proxy contest. The activist files their own proxy statement. There will be universal cards this year, but as you could see, the cards themselves don't have to look exactly the same, but the names have to be the same on them. The focal point of a proxy fight is about a month before the end. ISS and Glass Lewis, like judges, meet with the parties to the proxy contest. They meet with the board and management on the one hand, and the activists and the activist candidates on the other hand. They meet with them separately, unlike a judge, and more like a mediator. And they'll hear from them for an hour, hour and a half, sometimes 2 or 3 hours if it's a control fight. And then 2 weeks before the meeting, ISS's cutoff is actually 13 days before the meeting. Reports will be issued by ISS and Glass Lewis about which candidates should stay and which should go. Fight letters, press releases come out from both sides. And there's a significant engagement with institutional shareholders that takes place in that last 2 weeks. Once ISS and Glass Lewis come out, there's a race to get to BlackRock, Vanguard, Fidelity, and State Street before they cast their vote. And spoiler alert, they like to wait until the eve of the vote to cast their votes. So we're always biting our nails. And guess what? That's why these things settle, because folks get nervous. Next slide. We're doing okay on time here, so I'm going to slow it down a little bit. And then after this slide, there's a poll question, which we'll get to in a second. So advanced preparation. Usually companies that are very well prepared have a team in real time, in peacetime, ready to go. That usually includes a law firm with specialization. It usually includes a communications firm or PR firm that has experience in shareholder activism matters. It's highly specialized. Proxy solicitors are incredibly important. They help with all of the plumbing involved in soliciting votes, gathering votes, facilitating serial mailings, setting up calls with institutional investors. And there are some proxy solicitors out there that have done, we said we've done 250 plus campaign defenses in recent years. There are some that have done thousands. So very important to have one with you from the beginning. And then investment banks and boutique advisory firms are very key, particularly when there are very sophisticated financial arguments being advanced by the activist. If there's an argument being made that the company must be sold, you're going to need the financial engineering acumen in order to explain why that's not the case. And that's the role that they play, highly specialized. Not every investment bank has this type of specialization. There is a question after this slide. Does your company have a written activism response plan that also identifies team members? Yes, no, or not applicable? I'm not sure what I need to do now since I don't have a clicker, but I'm assuming we can go to the next slide. All right. Universal proxy, which is not one of the bullets here, although it would probably fall under structural defenses or corporate governance analysis. Let me just deal with that. Right now, there's a case pending in Delaware about bylaw amendments that were done by a company called Massimo after a 13D was filed and a campaign went public. And there were some significant bylaw amendments made beyond just seeking certification that 14A19, the universal proxy rule, will be complied with. As that works its way through the court, we'd like to see how the court comes out on some of these, we'll just call them robust, without sharing our views, robust bylaw amendments and defense mechanisms. We'd like to see how the court weighs in before we really dig in on how much bylaws should be changed now that we're in the universal proxy era. So for right now, there are a number of clients that want to tweak their bylaws just to contain specific references to certifying that there will be compliance with the universal proxy rule. And we think that is a good idea. You're, of course, still subject to the universal proxy rule, regardless of whether it's in your bylaws, but adding it as another requirement for certification is another advance notice element that you could request of your shareholders. And I think Jillian will talk a little bit more about this later. In terms of other ways to get prepared, work with your team on an intellectually honest financial self-evaluation. The markets have been really tough this year. It's a ripe environment for activism. Look at your corporate governance through the lens of an activist. Don't be too aggressive with your defenses, particularly while there's a case pending in court. Watch your stock very closely. Work with an experienced IR firm. And we have 10 times as many slides that we could do for anyone in a boot camp. And it also gives CLE credit, but not more CLE credit than you're probably getting from this right now. We're at time, or Robert's going to hook me off with Patrick.
Okay, welcome back. You're on the last stretch. Hope you did your little chair yoga and stretched around a little bit. And we now just have the group that stands between you and lunch. And we'll be pleased to start with Dario Mendoza, who is in our Employee Benefits and Executive Compensation group, doing this remote for us today. Dario?
Thank you, Robert. Yeah, so thank you all for being here. I'm going to cover a couple of recent compensation disclosure updates. I know we're on schedule right now, so I'll try to keep it that way. Next slide, let's get going. So the first rule I want to cover is the pay versus performance rule. Next slide. As some of you might recall, Dodd-Frank was enacted back in 2010, and that included a mandate that the SEC adopt pay versus performance disclosure rules. They issued a proposed rule back in 2015, which was never finalized. The SEC reopened the comment period for that proposed rule earlier this year, and in August 2022, they adopted the final rule. So that's a long period of time from when Dodd-Frank came out and sort of issued this mandate to when we got a final rule. You know, what's happened in the sort of compensation arena since, you know, those 12 years have passed? Generally, companies have shifted more towards granting performance-based awards. There's a couple of reasons for that. It might be say on pay votes, which started in 2011. It might be preferences from investors, you know, driven partially by proxy advisory firms like ISS and Glass Lewis that have really pushed to have a greater proportion of compensation be performance-based. So not only have we seen that happen, we've also seen over that amount of time, you know, the complexity of those performance-based awards change. We've seen awards with more metrics, different weightings and whatnot. So maybe when performance awards first came out, TSR was a pretty common measure. Now you're seeing companies do a lot more than just TSR. So next page. So the SEC did seem to try to take some of those changes in landscape into account when they issued this final rule. Okay, so the final rule is effective for 2023 proxy statements. It applies to proxy statements and information statements, but it does not apply to 10Ks. So if you include your 402 disclosures in your 10K, you actually do not have to comply with this pay versus performance rule. It's sort of an interesting decision from the SEC. In the adopting release, they mentioned that they view this disclosure as relevant when a company is going through a say on pay vote. So that might be why they sort of tied it to a proxy statement. But nevertheless, if you're a company like an MLP that only does a 10K and you don't do a proxy statement or information statement, then you do not have to comply with these rules. What is the final rule looking for? The final rule is looking for companies to disclose in their proxy or information statement the relationship between executive compensation actually paid and the company's financial performance that goes beyond just TSR. That includes three primary components that the SEC is looking for. Number one, a table. Number two, additional disclosure on the relationship between the compensation you paid and your company performance. And then finally, a list of your most important financial performance measures. This rule applies to all reporting companies other than emerging growth companies, foreign private issuers, and registered investment companies. Smaller reporting companies do have to comply with this rule, but they're permitted to comply with the relaxed disclosure requirements. Next slide. So this is just a blank table. This is what the first element of that disclosure, the table itself, is going to look like. You'll see for the rows, we've got 5 years of data, and then we've got some columns. We've got summary compensation table totals for your CEO, and then the average for your other non-CEO NEOs. That's disclosure you're already preparing, so that's not a new requirement. You're simply taking those summary compensation table numbers and putting them somewhere else. The new elements are this compensation actually paid calculation that we'll talk about on the next slide. And then you've got some financial performance measures. You've got TSR, you've got peer group TSR, net income, and then a company selected measure. We'll walk through all of those in a moment. Next slide. So what does compensation actually paid mean? As a starting point, you actually go with your summary compensation table number, and then you make two adjustments. One adjustment is for pension values, and then one adjustment is for equity awards. So what the SEC is trying to do in particular with respect to equity awards is revalue those to show year-end or year-over-year changes in fair value. So some of you might be aware that in the summary compensation table, equity awards are valued based on the grant date fair value. So you include that award one time, and then it just anything that happens, whether it vests or is forfeited, there's no adjustments made beyond that point. Now, what compensation actually paid tries to do is reflect, any forfeiture that occurred by deducting value. It tries to reflect any change in the company's stock price that maybe led to an increase in value and sort of add that in. So you're in all likelihood going to get a different number for the equity award column. In particular, if you are a company that grants a lot of equity awards over maybe a longer vesting schedule, so 3 or 4 years, you'd have multiple years of grants that are getting picked up in that adjustment calculation. Next slide. Okay, so the financial performance measures we talked about. So there's 3 of them. We've got TSR. And so the company is supposed to include their TSR for each year in that table based on the value of a fixed investment of $100. That's the same calculation that you're using for item 201E if you're including the performance graph in your 10K. In addition, you're going to have to disclose the cumulative TSR of your peer group. And the SEC gives you a choice. They say you can use the peer group that's the same as the one you're using for item 201E, that performance graph, or you can use your peer group in the CD&A. Now, this isn't in the adopting release, but the SEC has indicated informally that if you're benchmarking, if you're measuring the compensation you pay against peer group data, then you should be using that peer group in your CD&A. But if you're not doing that, then the relevant peer group to use is the item 201E peer group. Note that small reporting companies do not have to present peer group TSR. Okay, so then the next column is net income. That's just net income calculated in accordance with GAAP for each given year. And then you've got a company selected measure, and this is if applicable. So companies are supposed to include the financial performance measure not otherwise represented in the table. So not TSR, not net income, that you determine represents the most important financial measure used by the company to link executive compensation actually paid to company performance. If the company for some reason doesn't use a financial measure to that extent, or if they just use an existing measure that's already in the table, like TSR or net income, you are not required to include a company selected measure. In addition, smaller reporting companies are not required to include it either. Next slide. Okay. So what's that, the next piece, we covered the table. What's the next piece of disclosure? It's the additional disclosure where you're supposed to explain the relationship between executive compensation actually paid and the company's financial measures. So again, it's TSR, it's net income, and then if you have one, the company selected measure. Companies are also able to include additional voluntary performance measures in that table we just discussed. You certainly don't have to, but if you do that, then the SEC says you should be including, additional disclosure referencing those additional voluntary measures as well. And that disclosure can be a narrative, it can be a graph or a chart, it can be a combination of both. My guess is many of you listening right now are already doing something like this in your CD&A, where you're sort of, explaining your pay for performance philosophy, and you might be using charts to do that or narrative to do that. I expect that you would sort of follow the same pattern there, here as you do there, but it's really up to you. The SEC has given us some discretion in order, how we present that information. Next slide. Okay, so finally, the final piece of the disclosure is the tabular list. So companies are supposed to include an unranked list of 3 to 7 of your most important financial performance measures used to link compensation actually paid to company performance for the given year. It should include the company selected measure if you have one. You're also able to include non-financial performance measures if you view them as among your most important, but that's only to the extent you disclose, actual financial measures to the extent you have them. So the SEC, I think, is looking for 3 at a minimum. But again, if you don't use 3, if you just use 1, or you don't even use any, you're not required to include this list. Next page. Okay, so let's talk about, we've already mentioned that the first time you're going to have to include this disclosure is your 2023 proxy. How many years are you going to have to cover? The first time you do this, you're going to have to cover disclosure for the last 3 completed fiscal years. Or if you were a reporting company for less than that, it's the number of years at which you were a reporting company. Then the following year, so now we're talking 2024, you're going to add another year of disclosure. You'll have 4 years of disclosure. And then finally, the next year in 2025, you'll add the 5th and final year to the disclosure. So it's sort of a step-in transition period. Smaller reporting companies, the first time they do it in 2023, only have to include the last 2 completed fiscal years. And then smaller reporting companies have a 3-year maximum instead of a 5-year maximum in subsequent proxy or information statements. Next slide. Okay, so what do you do now? I just threw a lot of information at you. This is a big change to item 402 and the disclosures that you're going to have to prepare. So number 1, just be prepared for those more complicated and robust compensation disclosures. I've got clients that are reaching out, on a daily basis right now, sort of wanting to understand the info that they'll need to gather and think about how to present this information. So good idea to get a jump on that, just given the pretty substantial change that the SEC gave us. Number 2, start thinking about financial measures in relation to NEO compensation. You're really going to have to sort of sell the link between TSR and net income, or, alternatively explain why the link isn't so strong there. So start thinking about that. Think about your 3 to 7 most important performance measures for the list. And then finally start gathering data now, because there is a lot of information that goes into these disclosures. On that point, let's go to the next slide. Here is a high-level list of the information that generally you're going to need to prepare these new pay versus performance disclosures. I won't go through all of them, but after the presentation, you'll have access to the slides. Please take a look at these. And if you want more detail, I'm more than happy to provide that. But this is just intended to give you an idea of every little piece of info you'll need for those 3 different disclosure components we talked about: the table, the additional disclosure, and then the list. Next slide. So earlier I mentioned that we do have a sample calculation of how you perform the adjustment for compensation actually paid for equity awards. I don't think we have time to go through line by line, but I'm just going to kind of briefly summarize what this is, and hopefully you can take a look at the slides after the presentation. So we're just assuming that we're calculating compensation actually paid for the CEO. He received $5,000 last year. He also received 1 new equity award that's vesting in 3 years. He has 3 other outstanding awards. 1 of them vested during the year. 2 of them are still outstanding, won't vest until later. We've got changes in the company's stock price. It sort of started at one point, went up a little bit, then went down a little bit. Next slide. So this is sort of walking through the different calculations that you have to do. And I mentioned this briefly earlier, but essentially what you're doing is for anything that vested during the year, you're calculating any change in fair value that happened on the vesting date, adding that in. You're subtracting out the grant date fair value for any awards that were granted that year. If any awards were outstanding at the end of the year and the fair value has changed compared to the prior year, you're adding that value in too. So these are the adjustments you would make to your summary compensation table number to, in part, get at compensation actually paid for that table we talked about. Okay, next slide. Clawbacks. So this was the other big rule that the SEC recently enacted. Next slide. And again, it might seem familiar, but this was part of Dodd-Frank. So back in 2010, Dodd-Frank mandated the SEC to adopt rules requiring the stock exchanges to order public companies to implement a clawback policy. Same thing in 2015, we got a proposed rule. It was never finalized. And then last year and then earlier this year, the SEC reopened the comment period for that proposed rule and finally adopted a newer, more onerous rule than what was proposed previously just last month. So the new clawback rule is differently from the pay versus performance rule. This one applies to nearly all listed companies. So it does apply to emerging growth companies, foreign private issuers, smaller reporting companies, and controlled companies with very few exceptions. Now that the rule's been published, within 90 days after that, NASDAQ and NYSE are supposed to adopt listing standards that would compel public companies to implement clawback policies. Those listing standards would be effective within 1 year following publication. And once those listing standards are effective, companies would have 60 days, up to 60 days, to adopt clawback policies sort of in line with those listing standards. So all of that to mean we've got a little bit of time on this one, even though the SEC final rule is out. It's on NASDAQ and NYSE to now go adopt listing standards that implement that final rule. And those listing standards could differ in some ways. So we are recommending that clients sort of wait and see what those listing standards look like. Nevertheless, it's a good idea to look through the final rule just to kind of see what's changed. Next slide. Okay, so the final rule requires that a company recoup incentive compensation that was erroneously received by current and former executives during the 3-year period preceding the date that the company has to prepare an accounting restatement due to material non-compliance with any financial reporting requirement under the securities laws. The way the SEC is using the term received is sort of synonymous with how we view the term earned for compensation purposes. So it doesn't necessarily mean that the compensation's been paid yet. It just means that the financial performance measure tied to that incentive comp has been satisfied. So you could have an award that financial performance is determined as of year end, but maybe it's not paid for a few months later. That's what received is getting at. Recoverable amount is on a pre-tax basis. It's the difference between the incentive-based compensation received by the executives and the amount that would have been received based on the required restatement. Next slide. Unlike the 2015 version of the clawback rule, which is limited to big R restatements, this rule picks up both big R and little r restatements. So big R restatements restate historical financials to correct errors that were material to those previously issued statements. On the other hand, little r restatements restate prior period information in the current financials. The SEC estimates that little r restatements are approximately 3 times more common than big R restatements. As a result, the new final rule is a lot broader than what we originally expected based on the proposed rule. Next slide. Here's just a list of changes that would not trigger application of the clawback policy. Just the SEC isn't viewing these as things that would require clawback. So, for example, retrospective application of a change in accounting principle, retrospective revision for stock splits or other changes in capital structure. That's just a list you can review. Let's move to the next slide. Okay, so executives covered by the final rule consist of both former and current executive officers. So that's another change from the proposed rule. We're picking up former executives as well. That generally means your president, principal financial officer, principal accounting officer, vice president in charge of a principal business unit, division, or function, or anybody else who performed a policy-making function. If that definition seems familiar, it's because it's very consistent with the Section 16 of the Exchange Act definition of officer. And note that another change is that it doesn't require that there be bad conduct or a bad act or misconduct or anything like that on the part of an executive officer. Simply the fact that a restatement occurred and incentive compensation is affected by that restatement is all that is needed to trigger this clawback rule. Next slide. Incentive-based compensation, that means any compensation that's granted, earned, or vested wholly or in part based on a financial reporting measure. So that picks up not just accounting-based metrics that are in your financials, but also market-driven metrics that are sort of related, but not necessarily directly in the financials. So that includes stuff like TSR and stock price. The SEC acknowledged that calculating the recoverable amount for something like TSR or stock price could be difficult. So they allow you to come up with a reasonable estimate, but they do require that you provide documentation to NASDAQ or NYSE regarding the methodology that you use to determine that reasonable estimate. And again, the amount to be clawed back is the difference that should have been received by the executives based on the restatement versus how much they did in fact receive before that restatement. Next slide. So additional disclosure requirements, triggered by this clawback rule. All companies now have to file their clawback policies as a tagged exhibit to their reports, regardless of whether the company's ever been required to use that clawback policy. In addition, Forms 10K, 20F, and 40F are going to include new checkboxes for the company to indicate, number one, whether the included financial statements reflect a correction of an error, and number two, if any of those error corrections are restatements that require a clawback analysis, for any executives. If a company does have to apply its clawback policy, the company has to disclose facts regarding, what happened. So the date, the amount, the analysis of the calculation, amount still owed, and if you haven't collected that money yet, sort of the fact that you didn't and why you haven't. Finally, if you do clawback compensation, it could trigger additional disclosures within your summary compensation table for that period. Next slide. So what do you do now for clawback policies? If you don't have one, it's a good idea to start thinking about one that's in line with the final rule. If you do have one, it's a good idea to start evaluating how your policy might be different from the one that's in the final rule. Many companies back in 2015 or shortly thereafter adopted a clawback policy in line with the proposed rule. We've mentioned it a couple of times, but the final rule is a lot different from that proposed rule. So simply because you have one in place now that was based on that proposed rule doesn't necessarily mean that you're going to be automatically compliant. It's a good idea to analyze that rule and make sure that you adjust for any changes that you might need. Finally, start looking at your incentive compensation arrangements and see if there are any changes that you need in order to ensure that the clawback of compensation under those arrangements is permitted.
Thank you, Dario, and I invite Jillian Hobson to join me. Just a couple of observations on the clawback. If we think that bonuses based on accounting results may encourage accounting chicanery, do we think that a clawback policy will discourage chicanery or encourage people to try to avoid restatements at all cost? Their thinking is it will improve the processes. I think we'll just have to see how that plays out. I worry that people are going to push against any kind of restatement that's not within the exception list much harder because of the clawback. I really don't like the idea of potentially having to sue former officers or directors to get money if they don't just pay it up. You can always withhold on existing people, but you've got to think about what it does to their cash flow and their motivation. So this one's going to be rather interesting, I think. Jillian, let's step away from the Securities and Exchange Commission for a minute and feel the refreshing breath of fresh air as we turn our attention to state law and governance issues.
Yes. So the SEC sort of taketh away and Delaware giveth. So we're fortunately we've had a few changes in last year that I think actually are beneficial, which is probably a little bit different than what we've been talking about. The first one,
Big one up here.
okay, being exculpation for officers. So traditionally, directors, I say traditionally, when the statute was adopted, 102B7 of the DGCL, when that was adopted, it initially really focused on exculpation for directors, not for officers. And at the time, the thinking was, well, directors will take all significant decisions to the board. The board will then act on those. And so officers will effectively be protected from any sort of breach of fiduciary duty by having the board sort of overlay. Well, there was WorldCom, and there were a number of other large corporate cases, implosions, in which it was determined that, yeah, officers can actually have a breach of fiduciary duties as well, and particularly the duty of care. So Delaware, in looking at this, you can have an odd result where you have a company that's sued, the directors are sued, the officers are sued. The directors will be dismissed because they have the benefit of exculpation, and your officers still remain subject to the same constructs. And so what Delaware has done is said, no, we're going to give the same benefit to officers, but only to the extent that we currently give it to directors. And that is for breaches of the duty of care, they can be exculpated. What that means is, they still have to act in good faith. They can't commit fraud and the like. You can't exculpate someone for any of those violations. But on this front, there is now a benefit. We're not sure where ISS is going to come out when we expect we'll see virtually every public company change their charter to incorporate this. That will require, as we note, vote of the shareholders. There is a chance, I suppose, that ISS or Glass Lewis could object in some fashion. But again, this is really making it consistent with the benefits that already accrue for directors. And so we don't really anticipate that there should be much controversy around this. Any thoughts? Okay.
No, that's right. There's variations. Some people have kicked around. Do you put caps in there? Do you carve out certain kinds of behavior? I think you can debate that. My own personal view, which is not necessarily the firm's view, is I don't know why they should get a worse deal than directors. But those are the kinds of topics that a governance committee should be discussing. So this is on the, this isn't a sin not to do this year. This is a consider, have the discussion. We think a lot of people will do this change this year, and so that just makes it a good time to do. But you need to queue that up with your governance committees.
Yeah, and I'm going to try to be brief because we are running short on time, and we don't want to.
We have a lot of flex on MD&A at the end.
We don't want you to be late for lunch, but just look at the officers that are covered. I mean, there are some restrictions in that category, and again, make sure you understand what is permissible or exculpated behavior under the statute versus what's not. Moving on, let's see, next slide. So the other updates. So for those of you that deal with annual meetings, there was a requirement that both prior to the annual meeting, you would make the stockholder list available for the requisite period of time, and then you'd also make it available during the meeting. Well, Delaware has decided that making it available during the meeting is not necessarily required any longer, and so DGCL Section 219 has been amended to remove that. So this is something that's very simple to update for in your bylaws, doesn't require an amendment. That's one change that we're making for clients who are reviewing bylaws this year. The other update that's been adopted is for Section 222. And this one's really sort of a conforming change as we deal with all of the technology, advances in technology. Really, the Delaware statutes and other statutes have been updated as well. 232, which governed the means by which you would give stockholders notice of meetings, was amended a few years ago to provide that you could use email, courier, other things that are more current, I suppose, than just sending it out by snail mail. And so 222, the requirement that you actually give the notice, has simply been amended to clarify that the form of notice that's provided can be done in accordance or should be done in accordance with 232. So that's sort of a technical cleanup item. The other thing that was done was interesting is, we are all seeing these video conference and virtual meetings. And unfortunately, occasionally technology will play into that. And, you may have a meeting that was being cast and then for some reason is, no longer cast. And so there was a technical question about, do you have to give notice? How do you give notice? And the like. And so there's a clarification to 222 that if you adjourn a meeting, including for technical failure, that you don't have to provide additional notice of when the meeting would be adjourned or reconvened rather, if it's been provided either via the webcast networking system and the information's available. So again, another technical point that we would clean up in bylaws if you're making an review of what they currently say. You thoughts on that?
Yeah, just an observation that we went from all personal meetings to all virtual meetings over the objection of some of the so-called governance professionals. And I think where the world is settled is that we'll see some companies stick with virtual, but I'd say over the next few years, it's going to be mostly a mix. It's a combination of in person and virtual. So you just have to think a little bit through your rules and procedures to make sure it's consistent with how you're doing that, and make sure your bylaws give you the choice to combine, because some of the bylaw provisions that we saw out there contemplated one or the other, but not both. So just look at your language and make sure you've got the flex. Yeah. Flex is the key in bylaws in many cases.
In many cases, for sure. On the universal proxy rule, so we talked earlier, Catherine's part of the presentation, and Lawrence and Patrick's, about universal proxy card, what that requires. So I won't go back over that again. Suffice it to say that in connection with adopting Rule 14A19, that there are some changes that likely need to be made to your bylaws. Just acknowledging again that is another means by which stockholder nominees, director nominees can be provided. So looking for language that may appear to be inconsistent with the rule. There are probably a few other tweaks. I think Lawrence mentioned earlier the certification process, whether or not you would have an activist investor actually certify that they've complied with the rule, whether or not you include that language in your bylaws. I mean, compliance is required with the rule, obviously, if they're going to propose directors for the proxy card. But they're just, again, a few cleanup tweaks that we would suggest you would make as a result of this rule being adopted.
So in Lawrence's presentation, he commented about, I guess the way I would restate what he said is, don't be too aggressive. There's litigation out there about somebody that adopted what were at least alleged to be very aggressive provisions in connection with some 14A19 amendments. What we're talking about here in this presentation is very basic nuts and bolts, making sure the mechanics work, making sure that it interplays properly with your advance notice provision. And the bylaws are written very differently, so there's not just kind of a single provision you can drop in without reading what the rest of your document says. But the goal is to be clear that in addition to what you already have in your advance notice provision, they have to comply with 14A19 and provide you the additional certifications that go there. And to be clear that the deadlines in your advance notice provision, if they are earlier than the default provisions in 14A19, that those still apply. The SEC said in its adopting release that the 14A19 provisions don't necessarily supersede the advance notice. You're supposed to comply with those. But if you just drop in a language that says provide the stuff required in 14A19 and it goes in the proxy, you've just superseded your advance notice provision. So you want to write it in a way where it's clear you get the protection of what you've got, plus require them to comply with these things. Generally, those changes don't have to be made in proxy access provisions because those are designed to tell how you get onto the nominees go onto the proxy, as well as in the proxy statement. Universal proxy is just about the proxy card.
Just about the proxy card. Yeah, and the other thing, so the litigation's ongoing, which we would expect would temper most companies from wanting to be too aggressive on these changes. But there are some who will use this as an opportunity to include a host of other provisions that may be viewed as being more shareholder friendly. And the shareholder activist council who sent a letter to directors, advising against that and suggesting that directors weren't being presented with all of the facts around these changes. And my point in raising that is simply to say, when we talk about these changes wholesale, I mean, to the extent that they are immaterial and simply modifications to update for rule changes, that's one thing. With all governance documents and all of the changes that we're proposing, however, to the extent that it's substantive, it is important to make sure your directors understand what they are approving, right? So, I mean, they have a duty of care, and part of that is making sure to the extent that there's some material change to governance or other documents that would impact shareholders, either their access or ability to vote, and that your directors really understand that. Because the worst thing is in litigation to have directors say, yeah, I didn't realize what I was approving. So we just caution you with all of these to make sure that adequate information is provided.
Yeah, provide them the information, provide it in advance of the meeting, make it clear that you've explained in the written materials so that you have created a record to show that the duty of care was satisfied.
Okay, so moving along, we're going to flip-flop a little bit between Delaware changes and then also some of our corporate governance documents. And to piggyback on something that Rebecca said earlier today, it's really important that someone at the company or your outside counsel review your corporate governance documents and have a conversation to ensure that your disclosure controls and procedures are actually matching up with what your corporate governance documents say you're doing. And to the extent that there are things that you are not doing, that you consider whether you need to just remove those from those documents or modify them to match up with your process. So the first of which, and some of these, of course, lead to disclosure obligations. So the first of which we'll chat about here. Those of you that deal with securities disclosures and filings know that under item 502B, if there's a notice of retirement or termination and like for either a director or officer, that results in a disclosure obligation under Form 8K within 4 business days of the notice. So we spend a lot of time talking to our clients. In fact, this is a very common, well, we're, considering there's going to be a change in CEO, there's going to be a change in, pick your officer and, what do we have to do? Is it, do we have to disclose it? When do we disclose it? And it really is a facts and circumstances. But one of the things that we would like to suggest our clients do that we think is helpful in making sure it's clear what the facts and circumstances are when the notice is actually effective, when it's actually given, is to adopt an actual policy or a procedure, whether it's in your bylaw or in a separate document that says, in order to tender notice of your resignation, here are the things you have to do. You have to put it in writing. You have to provide it to the corporate secretary or the general counsel or whomever makes sense for the position. And so that you have a clear process by which you can then determine whether your 8K obligation is triggered. So that would be one thing that we think would be prudent to evaluate, whether you can implement that and have a process around it. Because I tell you what, I got a call the other day and a client was saying, well, the CEO is going to get up in a meeting and tell the board that he's decided to retire at the end of the year. And so we go into a frenzy about, okay, wait, what is he going to say to whom and why? But certainly in an instance like that, if your notice of resignation has to be in writing and you're simply trying to have a conversation around the timing of the event, those are different facts. And so we would submit that you would, make sure you have a process that's helpful in determining when you have disclosure obligations.
Yeah, the SEC has said it is a facts and circumstances analysis, which may be colored by your governance documents. So it's not conclusive, but this is a way of moving the needle in favor of, let's talk about this. We've got a little bit of time.
Yeah, I mean, there's guidance that suggests that really just making the statement could be viewed as being the dispositive fact. We'd like to move away from that. The next provision that we would submit you should look at in your bylaws is around exclusive forum. And so for those of you that have been involved in any sort of M&A transactions or other significant transactions in which there was multi-state jurisdiction litigation, it is very, very helpful if you have a provision in your bylaws that says, for these types of matters, jurisdiction is Delaware Chancery Court. For these types of matters, securities matters, we've got to go to state court. Just to try to eliminate the forum shopping that it can occur when you have these large transactions and having to deal with litigation in multiple jurisdictions. There is a little bit of uncertainty around the extent to which some of these provisions can be enforced. I think California, no surprise, it's a little unclear whether or not they will actually uphold certain types of bylaws. But this is one that you should look at that I think can be very accretive to the company if you're able to sort of direct the right jurisdictions in which you would have litigation.
Yeah, in Delaware, for example, and I'm not aware of any case that's tested this under Texas law, okay? And we have some public Texas company clients. But under Delaware law, it's pretty clear that certain internal affair type cases can be limited to the jurisdiction of Delaware Chancery or otherwise an applicable Delaware court or the federal court for Delaware. The Securities Act, the courts have held that state and federal courts have concurrent jurisdiction. And so you see a lot of plaintiffs going to the state court because they get around the Private Litigation Securities Reform Act restrictions on pleading and on when discovery can begin because they're in state court. So they start dumping the discovery requests right away. And, it's easier to get through your motion for failure to state a claim and dismiss early on in the process. So that's one that I think more and more we think people would like to strongly consider. And then it's the Exchange Act. Exchange Act is federal jurisdiction only. The question is, can you limit it to a particular set of district courts, or whether that has to be any federal district court? That's where the uncertainty is on that one.
Yeah, there were two separate, I think, courts that had basically the opposite holdings. And so it's a little unclear. But again, I mean, I think, just from thinking about how you manage litigation particularly at a public company, this is one that is sort of an easy, put it in, there may be some risk around the language. Now, there is it's not entirely clear whether ISS and Glass Lewis would object to this being done in bylaws without shareholder approval. But, that doesn't necessarily mean you shouldn't do it. And we'll see how that evolves. Next we are, insider trading policies. So there were a couple of slides earlier on that pretty extensively lay out the proposed rules for 10b5-1. And so we won't talk about that again. Here, the point of including this on this slide is to, again, reiterate what Rebecca said earlier. And I think it is really prudent. We don't know exactly when these rules will be adopted, but there will be amendments adopted presumably in the not too distant future. And there is likely to be a disclosure obligation. I mean, if there's one trend that we're seeing out of the SEC is they want you to post everything, and they want that mandatory, and they want people to be able to see what your policies are, and then they want to be able to come in and see whether or not you're complying with that.
No information is too small for the needs of the investing public.
Yes. The materiality overlay that used to exist, not exactly sure where that lies, but there's sort of a presumption if it's a corporate governance policy, it should be posted and available for folks to review. So in light of that, and in light of the discussion we had around shadow trading enforcement, one, make sure that if the company's intent is to police behavior from a 10b5-1 perspective, that it understands the scope of that policing activity and has the appropriate controls set up to actually monitor that. And two, just think about, whether the information that's included or not, or whatever your cooling off periods are, whatever the provisions are, how that will be perceived from the public. So, you would expect that once you start posting these things, you could see yourself in a situation of having more shareholder interests on these types of policies. And so at this time, before we have the disclosure obligations, I think it's prudent to take a look at those and make sure that your controls are aligned and the intent is clear and the company understands what it's taking on.
Just very briefly on the next.
Sure. Audit committee charter, this is simply, there's some disclosure obligations that are required. They can be triggered either by board action or officer action. Here, the point is simply to adopt a policy that makes it clear that the audit committee triggers these disclosure items. They relate to misstatement of financial statement or restatement of financial statements.
And withdrawal.
Yes, and withdrawal, yes. So, okay, I'm out of time, so I'm going to share kind of, okay, last but not least, I think this is the last big point. So not sure whether you all read the Barclays case, but if you didn't, recommend that you do. There are two very important things that are very near and dear to a securities lawyer's heart. One is making sure that there are the appropriate number of shares are provided for under a registration statement. That requires that you have internal controls to monitor grants that you make to employees and whether those are forfeited and how the vesting occurs and the like. Very important to track that. If you don't track that, you could find yourself in violation of the SEC's rules, have rescission rights where you basically have to buy back people's stock. It's just not a good thing. And then on the same thing applies for S3s. And that was actually the Barclays situation that I've run out of time to explain, but I would submit that you look at it because it was just fascinating how they found themselves issuing like $17 billion worth of securities that weren't registered. That's a really bad fact. The other thing we would remind you, in addition to tracking the number of securities that are actually issued under your shelves, is that shelf registration statements, as listed on this slide, the ones that we list, can have a 3-year sunset provision. So again, you don't want to find yourself without a registration statement and be issuing shares in violation of the securities laws because that can be a costly mistake. And I think with that, their D&O questionnaire changes, which you all should consider. And then this is just a list of what we are suggesting that you evaluate.
So on the D&O, none of those is really a mandatory got to do it, but these are just some areas where people think you may want to just look at your D&O questionnaire. Part of your annual process, at least on S8s, should be to run your share counts against the S8 to see whether you need to get an additional S8 on file, and to separately track your share count under your plans. S8 counting rules are not the same as the replenishment provisions in your benefit plans. This is a common mistake. That's why we're flagging this.
And the other mistake is relying on your external provider to actually help you track that, because again, they aren't necessarily tracked in the same way. So the company does have to have an internal control and audit effectively every year of what have we issued under each plan and what's currently registered, and do we need to file an amendment to get additional horsepower.
Yes, some issuances will count against your S8 count, even though they get forfeited later and replenish the shares available under your plan. You've got to be aware of the differences there and just track them. Okay.
And with that, I will leave you to the scintillating discussion on MD&A.
Scintillating MD, this is, yeah. We'll, so our colleague Shelley Barber in New York was asked by the Practicing Law Institute to do a presentation at one of their conferences for smaller and mid-cap companies in October for about MD&A. And she invited me to help her with that. And what we decided to do was basically drop the slides in. Substantially what we did in that presentation there, so that you've got some good reference material. When we think about MD&A, so this is very little of this is new. This is an area that gets a lot of SEC comments. And so what we're trying to just briefly do here is reinforce to you some basic principles of MD&A and to pause for a moment on how they apply to some current situations and make sure that you know the MD&A resources. So I think that's a pretty critical piece for you to this is homework part. This is read through this part of the slide deck. If you've never read the linked releases, you ought to. Because a lot of MD&A questions we get, the SEC has used as examples already in one of their MD&A releases. So it's why, how, what, who, and when. We just did the journalistic approach to this. Why MD&A? Because that is what you need in order for your financial statements and your disclosure together to fairly represent what's going on at the company. It's the combination of the financial statements, the notes to the financial statements, and MD&A that round out the picture to help people evaluate what's really going on and to see it through management's eyes. How many times have we heard the SEC say that? Bring them into the boardroom, bring them into the CFO suite, help them understand. So when you start out your MD&A, there should be a nice, when we do IPOs, the bankers all make us repeat part of the business section there, right? But that's not really where we want to start as you're a more mature company. We want to start that lets people know early and quickly what the big stuff is that was meaningful this quarter, because you're going to separately go through the quarter by quarter, whether it's year over year or prior period to current period. You've got a choice now. Changes and talk about those. But this is where you really summarize the material things. And sometimes that takes some fresh writing. Sometimes, it's similar to the prior period. But that's what you're trying to do here. Help them understand it, see it through your perspective. This is not the area to say, do I gotta clean my room? It's the area where you say, what would people want to know? What would help them understand this? What tells our story? This is your quarterly opportunity to tell your story properly, And this is where people start reading. They skip the other stuff, and this is where they go to. So if you could do 2 paragraphs that really explain where you are, you've helped out Lawrence and Patrick when the activists are looking at which companies they're going to go at, because they'll say, here's somebody that tells their story and tells it well already. That knocks you down the list of a likely target a little bit, unless your story is, we're a disaster, we need help. Okay. Sometimes you got to be candid about that, though. So just try to think through how you do that. This is the list, the links to those key pieces of guidance. There have been plenty, but go read them. They'll help answer a lot of the questions that come up internally about what should be there. That's why MD&A, but MD&A is also itself about why. Why did this happen? Why are the results this way? Why are we facing challenges in this area, and what are they? So think about, we hear a lot about writing from a blank slate on MD&A. I don't think that means write all, 10 pages fresh every year without looking at what you did the prior quarter, the prior year. But I do think here's the exercise I would just suggest. CFO, here's a small piece of paper. Sometime in the next couple of days, would you just write down the 4 or 5 key things that you're worrying about and that you think explain what's going on in the company? Just a bullet point. Doesn't even have to be a full sentence. CFO, would you do the same thing? Head of Major Business Unit A, would you do that? Head of Major Business Unit B, General Counsel? And then compare notes. That's what's writing fresh. It's just stepping back without being bound by what you said last quarter and asking yourself, what's really important? Now, if you're in-house, one of the things you want to do is look at the board presentations, because if the management's telling the board this is important in those presentations and it's not discussed in MD&A, well, then you're in the Caterpillar enforcement situation. We have an aberrational quarter because of exchange rate improvements in Brazil versus the US. Otherwise, it'd be just sort of a normal quarter. Didn't put it in MD&A, it's in the board minutes. Enforcement action, okay? Those are the kind of things. That's what I think we mean by writing fresh. Oh, the other thing. Yeah, so we'll just explaining. Plain language as much as you can. Give the big top perspective up front. Just refresh those, what's most important. Okay, explanation and quantification. MD&A is one of the most heavily commented on areas of your periodic reports. Okay, and what do they comment on frequently? And we see this in inflation, we see this in non-GAAP. What changed? Why did it change? And quantify the change. In other words, 2/3 of this change would be because of an increase in labor costs. Okay, $30 million of this change was trying to stopgap a supply chain problem. Half this change is a rise in our variable interest rate in our credit facility. Okay. We can't quite estimate it, but we believe we lost a significant number of customers to worse hamburgers at a cheaper chain because of inflation. I mean, that's what you're trying to get into here. Feel free to use tables and charts. The comp people are well ahead of us on that, but tables and charts can really be helpful. If you do that, try to make sure that you've got all your periods in a single chart instead of having one chart for this quarter and another chart for that quarter where people can't quickly compare them. And don't get too duplicative. Just if you've got it already in the notes to the financials, feel free to cross-reference. So that's why, what you sort of know. I've hit the overview, what really ought to be there. I've suggested you don't need to follow the IPO practice of a business overview repeat, but clear description and quantification of unusual or frequent events or significant economic changes. What, why, how much? Liquidity and capital resources. This should be used to drive internal discipline for cash flow forecasting. If you need to go raise new money because you're in a desperate situation, it should not be a surprise to you unless it's an extrinsic event, like you're an airline and suddenly nobody's flying because there's this weird thing called COVID running around. Okay, you can't anticipate some things, but you should build discipline on this so that you have a good outlook and you're doing your fundraising early. Now, we every quarter there's somebody that just gets into a bind. It's surprising how many times they didn't foresee the bind when it was foreseeable in retrospect. And so you have to say, what are we doing to properly model out our business and our cash flows? And what are we saying about it so that people understand that if we can't sell this property or if we don't get a licensing deal or just if there's a lag because we're here in the chain from the client to the ultimate payment and we don't control this because we just manufacture or install this part. That's out of our control, and a little bit of a movement can change our revenues quite a bit quarter to quarter. That ought to be a little more transparent. Okay, so that's what in MD&A at a high level. If you're in the category here of people that have operational or non-GAAP measures in your press releases, but not in those same ones are not in your 10Ks or Qs, that's worth at least a discussion, and anticipate at some point that the staff may ask you to defend that. If it was important enough in earnings, why is it not important enough to be in MD&A? Operating statistics and non-financial measures. Okay, we've seen a lot of comments again from the SEC about non-GAAP financial measures. GAAP first. That means including doing your quarter-to-quarter results before you hit the section where you talk about your non-GAAP stuff. Better explanations of why the non-GAAP stuff is being used. Always, always, always identify it as non-GAAP and reconcile it. We see that comment, and I'll just tell you, we beat our heads sometimes against the wall trying to convince some people that that's the rule and that's the way it'll be. And they'll say, but so-and-so doesn't do it. Who's our peer? Okay, I get that. But that doesn't mean they're doing it right, okay? We're going to be asking you to always be non-GAAP compliant. You heard Catherine Frank say earlier, you didn't hear it. I heard it at dinner. She's been labeled non-GAAP police by one of her clients. Okay, in a sense we are. We're trying to keep you out of trouble there. That is an area that can spill over to an enforcement. I've talked to you a bit about liquidity and capital resources already. Critical accounting policies and estimates. This is not repeating your notes to the financial statements that explain your accounting policies. This is going in to explain judgment. It is tedious. It is boring. None of us likes to read it. None of us likes to write it, but that's what it should be. If something's hard to estimate, just say it's hard and this is why. Don't just go silent on it. Okay, it's an uncertainty. We'll let you read we'll let you read on your own the things most likely to draw comments. Who contributes to it? We've talked about disclosure committees. This is your team. Here's your poll. I guess the results will come up shortly. You are not obligated under the law to have a disclosure committee. But the SEC is always going to ask you the documents around your disclosure controls and procedures. And one of the questions they often ask when they're deposing you is, do you have a disclosure committee? Okay. So we did this poll at the PLI and 20% did not. Do we have our poll results on this one? Okay. I think a few of you ought to give us a call and we should talk about how you're look, maybe the problem is we call it a committee. Checklists, I'm going to go back to the very start. Checklists exist to help us remember and to facilitate communications among the right team. This is, don't think of it as a committee, think of it as your disclosure team where you pull people together to draw on their knowledge and their judgment to make good disclosure decisions. Then you call it disclosure committee on the piece of paper that documents that, and wow, you get to say good things to the SEC. So that's that. We'll skip through these. Oh, we've talked about clean slate. We'll see what the poll result is on that in a minute. And we've just got some process suggestions for you here on MD&A. So my guess is most people really don't start from scratch, but do that in your first paragraph or two. Step back, think about it, and do that. There are a list in the slides of the key topics the SEC has flagged recently. There's nothing special about any of them. You take the principles we just discussed and you apply them. Now one of the things I like about what they've done is in some of them, they put a list of questions you might ask. And they're a great list of questions as you consider the disclosure to go through. What happened? Why did it happen? How much did it cost? Is it incremental cost or is it stuff we're already doing? Is that material to any of our line items in MD&A or to the overall picture? They've got some really great questions in there. So it's worth flipping through some of those and saying, hey, we could use this to enhance our process just to help us do better. So that's there as a reference for you. We greatly appreciate your participation. Yeah, I 95% no, I'm with you on that one. But change that for the first paragraph or two of MD&A, please. The rest of it, I'm wholly on board with you. Okay? We really appreciate your attendance at the conference. For those of you who are here in person, we will have lunch. For those who are remote, we hope to see you in person in the future, but we will continue to provide this remote. We thank you for your time. Please feel free to send suggestions on how we can improve this and specifically on topics you would like us to see in a deep dive presentation standalone from this. Thank you very much. And thanks to all my colleagues for their hard work on this.